Item 24 minor. CD also minor, not there minor. So after 2 weeks minor. Item 24. Interim is there minor.
CD not. It should be fine. When can be? 10th of March.
Interim may be continued.
10th of March. It may be continued till next day.
Well, I'm mentioning for listing of a criminal petition for order on 20 my lord.
20.
20 my lord.
May I please, your lordship. Lordship, prayer for for withdrawal, lordship, be a pending matter, lordship. Can it be tomorrow, lordship? Be already charge sheet has submitted. That is why, lordship. Obliged.
May I please, your lordship. Permission for withdrawal of the criminal petition tomorrow, lordship.
Are you going to list flag? Okay.
I love you.
May I please, your lordship, I beg to mention one criminal petition for withdrawal, lordship, tomorrow. Much obliged.
May it please, lordship. I beg to mention an IA for suspension of sentence, my lord, last listed on December 2024, my lord. If it can be listed on in this week on the
This week is possible.
week
This
following,
week
my
may
lord.
be possible. Maybe on next
Under
week.
order for
Next
orders.
week, Monday, all Tuesday. 7th.
16th, my lord, maybe.
Already many matters. 17th.
May I please, your lordship? I beg to mention listing of IA criminal on Monday, lordship.
17th.
7th. Obliged.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 8, lordship. Kindly pass over the matter for today, lordship.
You are for the
Petition, respondent 3.
you are for the respondent. You have taken consent of the other side.
Lordship.
Order litigate. It will be listed after 1 week
Obliged, lordship.
as on the date.
May I please, your lordship? Lordship, I beg to mention for listing a criminal revision, lordship. Lordship, matter may be allowed for listing on Monday, lordship, 16.
No, not possible. Tuesday is a hairy date up in new Wednesday course. Weeks as about now Wednesday COVID. Wednesday is 18th. Wednesday and 18th.
May I please, your lordship? I would like to mention for item number 9, lordship. The matter may be passed over for 2 weeks, lordship.
You are for the petitioner or for the respondent?
Petitioner, lordship.
Petitioner.
Yes.
Have you taken consent of the other side?
Yes, yes, lord. I have informed.
With consent of the other side.
Lordship, interim may be
It by nature. Let the matter be accordingly listed after 2 weeks as an date by the next.
interim may be continued.
Interim was day. Interim be continued next.
May I please, lordship? Was praying for a listing criminal appeal on Friday,
Next Friday? No, not
on 13.
not at all. 19th of this month.
19.
19th, 1/9.
May it please, your lordship. Your lordship, I beg to mention for listing of a criminal appeal. Your lordship, it may be listed on 17.
In which column it has to be?
Your lordship orders.
Orders column? 19th. 18th.
May I please, lordship? I beg to mention for listing on regular bill application, lordship. Friday, lord.
No, not Friday.
Another case is
On Friday only.
yes, lord.
May it please, lordship. Lordship, I beg to mention for listing of one regular bail application in bail hearing column, lordship, on tomorrow, lordship. Similar matter is
possible.
Similar matter is pending.
In which court?
Bail hearing column, lordship.
In which court?
This court, lordship.
This court only.
Obliged.
May I please? Beg to mention for listing of a criminal petition for orders on 18.
18th.
Obliged.
May I please, your lordship, I beg to mention criminal revision petition. The last date of posting is on 6/11/2025. Finally, matter may be listed on Monday.
Monday, I don't know. 20. 20. 2020.
Bless your lord.
May I please, your lordship? Lordship, I beg to mention for listing of a criminal petition on the day after tomorrow, lordship, on Friday.
Not possible. Maybe on Wednesday, Monday, Wednesday. Oh, but 18 or 2 he Okay, that 18th.
18th.
May I beg to mention an item for hearing, but hearing Lordship,
What kind of item? Criminal petition, appeal?
criminal appeal Lordship.
Criminal appeal.
Yes, pending for hearing Lordship. Last it was listed on January Lordship, and petitioner is behind the bars for 3 years. So next week.
It'll be on the next week. Now see, we have fixed many part heard matter on next week. So Thursday, given 19th. In that case, 24th.
Oblige.
It's a hearing day, I think 24th.
Malra, I want to withdraw this two petition.
Hmm?
I want to withdraw this two petition. Next week,
He.
Monday,
Withdraw. What kind of criminal
the
petition?
criminal petition.
Okay,
Both of
Monday.
criminal petition. And another matter, RSA matter, it may be listed next week matter.
RSA. RSA.
Yes, ma'am.
I'm not taking the civil mention.
Oh, good thing.
Make a mention before.
Lordship, I'd like to mention criminal revision. It's a revision against conviction, Lordship. So this week or next week, this Friday or
Now see, Monday almost over. Tuesday we have some part heard matter. Thursday also. Where is 20.
Your Lordship, I have mentioned for orders. Your Lordship, that was my part of mistake. It was for hearing, Your Lordship.
On which day we have?
I was seeking for 17th of this month.
17 and 19 we fix our part heard matter. It won't reach also. And
Any
two we have
next day?
fixed some matters. So it won't
Any next
reach.
day, Your Lordship?
Next hearing day. You want to hearing day?
Yes, Your
Hearing
Lordship.
day means yeah. 24th by any. Twenty-fourth.
Please, Your Lordship, I beg to mention to bail hearing, Lordship. Kindly fix it on the 13, Lordship. It is
13?
from court number 8, Lordship. Referred from court number 8.
Oh.
Mass applies, Lordship.
May
Item number 37 and 41, bail hearing, Lordship.
Item number 37 and 41.
41.
Item number 37. Today's must.
Yes, Lordship.
May it please, my lord. Prayer for listing. My lord, matters were listed before court 8. My lord, items 36 and 40. 40. My lord,
36 and 40.
40.
36.
My lord, for tomorrow, if it pleases, my lord.
Tomorrow, better not to fix it. Tomorrow.
Friday.
Tomorrow already list is over. Yes, on Friday.
I'm so obliged, man.
My appeals. I beg to mention item number 20 on the daily list, bail hearing matter. There is some accommodation.
Yes, it's a hearing in hearing.
Bail hearing matter, madam. There's some
Received the
difficulty.
CD.
What's it?
We have received the CD.
Yes. There's some difficulty in some other day. Only for the day.
Are you on interim day?
Yes, Lord.
Interim was day.
Yes. Except Monday, Lord.
Pity consent to the other done it council for the additional Bitcoin item stating that due to some personal inconvenience, not ready to is to put so and so CD received. List when it can be
19 to
19.
19.
Okay, 19.
Deeply obliged.
CDB details are listed.
My pleasure, Lordship. No, I beg to mention item number 13, Lordship.
30.
13, 13. Case diary has not been received yet.
CD not received, man.
Any other?
13 we CD not received.
There's an interim order, Lordship, that may be continued.
In bail application.
Yes, Lord.
Interim was there.
Yes.
Interim, what kind of interim we were?
He was released on bail, Lord.
Interim bail.
Yes, Lord.
Started to divorce. I didn't know what.
10th of March.
Yes, sir.
It was the order of 9/1/2026.
You are Mr.
W. Rahman on behalf of M. Hussain.
W. Rahman, appearing on behalf of Mr. Galaxy. So hard to be bought. C did not receive. Issue reminder. Further, the interim order dated 9/1/2026 be continued till next date. Based on it
2nd of March.
second.
May I please, your worship? My lord, I beg permission for listing of a bail hearing matter, my lord. This matter was last listed in the month of December, my lord. And from that day, next date was not fixed, my lord. So till date matter has not been listed. Any date the next week, my lord.
Send 20
May I please?
20.
My lord, he is not in bail, interim, my lord. Anticipatory bail, my lord.
Anticipatory, yes, 2020.
May I please, your lordship, the listing of AB lordship, promotion lordship, any date of
21, 20, company.
motion lordship.
Okay. 20.
Give your
Yeah.
May I please, your worship? But this is a regular bail application, my lord. Lordship will kindly see page number 30. Page number 30, my lord.
Yes.
This Papu Bora, my lord, he is aged 25 years, and this Pradip Soikia, 18 years, my lord. They are the present petitioners, my lord. Papu Bora happens to be a driver, and this Pradip Soikia is a handyman of a truck, my lord. They were carrying, my lord, scrap materials, my lord, from Itanagar to Gauhati. Basically, my lord, their truck was hired by one Asanuddin, my lord, who had entered into some agreement, my lord, to sell scrap materials, my lord, to an iron factory in Guwahati, my lord. So accordingly, my lord, their truck was hired. And while they were carrying the scrap materials, my lord, at Biswanath Sariali, my lord, police detained their truck. And police alleged that, my lord, these scrap materials are stolen materials, my lord. Now, Lordship will kindly come to the FIR. FIR is at page number 21. And vernacular is at page number 25.
Yes.
May I read it, my lord? সন্মানপূৰ্বক বিনীত নিবেদন এই যে উপৰোক্ত প্ৰসংগ মৰ্মে উপ পৰিদৰ্শক বুদুৰাম মহোদয়ৰ লগত মই আৰু সংঘীয় ষ্টাফ সহ এক চোৰাংচোৱা খবৰৰ ভিত্তিত গৈ জিঞ্জিয়া থানাৰ অন্তৰ্গত টলগেট সমীপত 15 নম্বৰ ৰাষ্ট্ৰীয় ঘাইপথৰ ওপৰত নাকা চেকিং কৰ্তব্য কৰি থকা অৱস্থাত গহপুৰ দিশৰ পৰা বিশ্বনাথ চাৰিআলিৰ অভিমুখে আহি থকা সন্দেহযুক্ত চুৰি কৰি অনা ধাতু ভঙা চিঙা লোহা ভৰ্তি AS ইমান নম্বৰৰ মালবাহী ট্ৰাক গাড়ীখন আটক কৰোঁ আৰু চালক আৰু হেণ্ডিমেন উক্ত বস্তুসমূহৰ নথি পত্ৰ বিচৰা হয় যদিও তেওঁলোকে কোনো ধৰণৰ যথোপযুক্ত নথি পত্ৰ দেখুৱাব নোৱাৰে। মাথো 24 টন ভঙা চিঙা লোহা মাল অনা বুলি কৈছিল। পৰৱৰ্তী সময়ত উক্ত সন্দেহ হোৱা ট্ৰাকখন চালক হেণ্ডিমেন সহ সংঘীয় সহযোগত থানালৈ তদন্তৰ বাবে লৈ অনা হয় আৰু প্ৰাথমিক তদন্ত কালত তেওঁলোকক কোনো ধৰণৰ গ্ৰহণযোগ্য নথি পত্ৰ দাখিল কৰিব নোৱাৰিলে। গতিকে সন্দেহ হয় যে উক্ত বয় বস্তুসমূহ চুৰি কৰি আনিছে আৰু অন্য মূল্যৱান ধাতু উক্ত লোহাৰ ভঙা চিঙাৰ মাজত লুকুৱাই আনিছে আৰু সেইসমূহ অবৈধভাৱে ফাঁকি দি সৰবৰাহ কৰি আছে। উক্ত বয় বস্তুসমূহৰ গৰাকী নিম্নলিখিত 3 নম্বৰ পদকীয়াজন হয়। পৰৱৰ্তী সময়ত উৰ্ধ্বতম কৰ্তৃপক্ষৰ লগত উক্ত বিষয়টোৰ সন্দৰ্ভত আলোচনা কৰা তেওঁলোকে মোক আইনগত ব্যৱস্থা ল'বলৈ পৰামৰ্শ দিয়ে আৰু মই সেইমতে নিম্নলিখিত 1 নম্বৰ ট্ৰাকখনৰ চালক 2 নম্বৰ হেণ্ডিমেন আৰু 3 নম্বৰ পদকীয়া অৰ্থাৎ উক্ত বয় বস্তুসমূহৰ গৰাকীৰ বিৰুদ্ধে এজাহাৰ দাখিল কৰিলোঁ। So, my lord, this FIR was registered under 302, 3032, 318-4. Now, if your lordship will kindly see page number, my lord, 18 and 19. These are the, my lord, EUA bills and challans, my lord, wherein there is specific mention about the iron scrap and materials, my lord. And the truck number is also mentioned there, my lord. At page number 19, in the bill of supply, the truck number is also mentioned properly. Now, before starting, my lord, their journey, their truck, my lord, was verified by the police officer in charge of the local police station. That is in page number 20, my lord. It was verified by the officer in charge of the local police station, my lord.
Truck was coming from which district?
My lord, it's
Itanagar.
Itanagar, Chimpu area, my lord. But even after that, my lord, without any basis, my lord, the police of my lord Biswanath Chariali, my lord, they detained it on the basis that, my lord, these materials are stolen. Now, when this dispute arose, my lord, the petitioners supplied the information as to who the owner of the dismantled JCB was. Police said that this was a JCB parts, my lord. So, thereafter, my lord, lords will kindly see at page number 35 onwards, my lord. These are the affidavits, my lord, sworn by the owner of the JCB, my lord, who sold the dismantled parts of the JCB, my lord, to Asanuddin, my lord. He has sworn the affidavit and his details have been furnished to the police also. So, my lord, it's not that, my lord, police do not know as to who the owner is. Police is free to investigate this person, my lord. But even after that, my lord, without furnishing the 35(3) notice, my lord, which the Supreme Court recently has said, below 7 years offenses, my lord, the police detained them, my lord. And they are, my lord, driver and handyman, and the truck has already been seized, my lord. So, my lord, since, my lord, around 17 days have already passed, my lord, for the purpose of investigation, my lord, my humble submission is that further custody may not be required, my lord. That's my humble submission, madam. Everything is there, madam. Regarding the source of this scrap materials, the owner of the JCB, my lord, everything is there, my lord. Let the police investigate that, my lord. Everything is documented, my lord.
Your lordship, may kindly regarding my lord, first regarding my lord 35(3) notice, your lordship may kindly come to page 31, my lord. There are sufficient reason, my lord, why 35(3) BNSS, page 31 of the petition, my lord. Note, my lord, in view of the facts and circumstances of the case, the arrested accused could not be served with a notice under section 35(3) of the BNSS, as the offense relates to illegal possession, transportation of iron. So these are the detailed reasons. So regarding 35(3), why 35(3) not served, there are detailed reasons is there in page 31, my lord. Note. And regarding other materials, that these are the documents, EUA bill, all these documents, my lord. Then where is the apprehension? Why owner has not approached directly to the IO that these are my documents, that these are the valid documents of those scrap materials, my lord. So these are genuine documents. Then owner, my lord, till now has not, my lord, approached before the police station. But at the time of, my lord, when, my lord, those vehicle was apprehended and seized by police, at that point of time, were also, my lord, those documents which must be kept at with the driver and the handyman, my lord. Those documents were not produced while that truck was apprehended by police. And thereafter, my lord, bail petition was also moved before the trial court, my lord. At that point of time, also, my lord, those documents, my lord, I do not know, my lord. Trial court has not considered and rejected the bail petition. So now, my lord, why owner has not approached before the police, my lord? Where is the difficulty? Unnecessarily, my lord, he is the one is driver and handyman. They are now in police custody, and owner, while having all these documents, till now police fail to my lord, find where is the owner, my lord. If all these documents are genuine, my lord, where is the, my lord, my lord, difficulty to approach before the police by the owner?
That is up to the owner, my lord, whether he wants to approach or not, my lord.
Because
Whether
of-
with liberty or without liberty,
But, my lord,
it's up
presently,
to
my
him.
lord, from the possession
No.
of the two persons, those, my lord, scrap materials without having any police, my lord, at the, from the truck was apprehended, thereafter police arrested. And why 35(3) not, my lord, served, that is also specifically reasons mentioned. So these are the reasons. Regarding length of detention, my lord, that is up to your lordship, my lord. Otherwise, there are materials, and 35(3) also, my lord, comply.
Well, these are handyman and driver.
And main accused person, who is the owner, not yet arrested.
That is up to him, my lord. Now, these are driver and handyman, my lord. After valid documentation, my lord. Now, the case number 20, my lord, with the Chalan, which I have annexed, my lord, that was verified by the local police station also, my lord. So, they had carried this document, my lord. Now, after that, my lord, if the police requires any other documents, my lord, the police is free to investigate, my lord. Now, whether the question is this, my lord, whether further custody is required or not, my lord. Because truck has already been seized, my lord. Scrap materials are seized, my lord. Documents are there, my lord. Now, regarding the owner of the truck or the owner of the scrap materials, well, the police can investigate. But the thing is that there cannot be a ground to detain these two persons, madam, who are normally, madam, who are driver and handyman, madam. That's madam, on the ground of length of detention, madam, not even considered.
Mr. Esther, constitution. But you put it as an application. Next, subject by Mr. Constable. One. They got arrested on 8/10. When they got arrested?
26,
26,
26,
25, no, madam,
26 one.
27 one. 27
Then
one.
your post title is
At page number 30.
Well, poster wrongly mentioned as 8/10/25.
At page number 30, madam. Correct করছি দেখুন, তুমি correct করো।
That petitioner number 1 and 2 are the driver and handyman of the truck, which was intercepted by police at Visunacharili while they were coming from Itanagar by loading some scrap materials on the these two petitions. They are not related to the alleged offense. Rather, further he submitted that these scrap materials were loaded at Itanagar by one Asanuddin, who hired a truck for loading the scrap materials for Biswanath Shadi. Further, he submitted that while the truck was submitted that the local police also verified the materials and they then at Chimpo police station, and then only it was allowed to go. And thereafter, they were intercepted by police at Biswanath. Next, Mr. Asperger submitted that the scrap materials were purchased by the owner from a person who accordingly executed one affidavit also, where from is also seen that those scrap materials were from a JCB and were purchased through purchase, and then it was loaded for Biswanath. The way bills and the way bills and chala, the bill of supply, etc. also annexed along with the petition. Along with the petition, Mr. Das further submitted that these two petitioners are only driver and handyman the truck, and as per the instruction of one Asanuddin, the truck was loaded with two scrap materials. They are scrap materials which were also purchased by the owner, which remains from the UAP in the Chalas. Further, both the petitioners are in custody since 27/1/2026, and thus they are got sufficient opportunity to injure the accused, keeping them in custody. And hence further custodial detention may not be required for purpose of investigation. Next part, Mr. Botaku raised objection and submitted that. Oh, Mr. Duff submitted that though it is a case of below 7 years punishment, but no 35(3) notice was provided to both the petitions at the time of their arrest. Before their arrest. Next part, Mr. Botaku submitted in this regard that there is explanation in the boarding report itself as to why the 35(3) notice could not be served to petitions at the before their arrest. Further, he submitted that if why the accused, why the driver and why the accused persons could not produce the waybill, challenge, etc. at the time of their arrest, and the owner also did not approach the court, did not approach the police station, claiming his ownership of the scrap materials. There are sufficient materials from the FI itself. It is said that there are sufficient materials against these two petitioners, and hence their further custodial determination may be. And in the meantime, the CD may be called for to know the actual facts. Then submission made by learning counsel considered the entire facts of the case as well as the documents produced before the court and other aspects of the case. I find that further custodial information may not be necessary for the present petitioners who were only the driver and handyman of the same truck. All these scrap materials have already been seized and the LS truck is also under the custody of police. It's not like further custodial intervention or is required for this to petition in view of this. It is a case of where Biswanath CGM Biswanath.
Highly obliged.
May I please, Lordship?
Yes.
Lordship, the petitioner in this case is booked under section 3, subsection 5, 318, subsection 4, and 351, subsection 3 of BNS. Lordship will find the FIR at page 12, Lordship. Lordship, long FIR, but the basic allegation in this case is that the complainant, Prasenjit Borwa, he lodged this present FIR as he was involved in a limestone mining joint venture in Meghalaya for which he was looking for investment. And for that investment, the accused, the present petitioner, along with two other, they assured him of investment of rupees 20 crore, for which a demand was made of rupees 26,20,000 as commission. And out of that, rupees 2 lakh in cash was paid to the present petitioner, Lordship. That is the basic allegation. However, Lordship, the punishment of the sections which is attracted against the petitioners is up to 7 years, Lordship. And in this regard, the mandatory provision, that is section 35, subsection 3 of BNSS, is being violated in the instant case as no notice was served to the present petitioner for his appearance, Lordship, and directly he was arrested, thereby violating the mandatory provision of BNSS and also the guidelines that were laid down in the Arnish Kumar and Satyendra until judgment, Lordship, where it is clearly laid down that non-compliance of Section 41 and 41A of CRPC would entitle the accused for grant of bail. That's my humble submission, Lordship.
Regarding that, it is my lord, from the present petitioner is the my lord, he was at the time of commission of the offense, he was the my lord deputy manager of the Punjab National Bank, my lord. And only because of his insistence, my lord, he, my lord, assured to the informant to provide a loan of rupees 20 crores if he invests such an amount, my lord. Thereafter, my lord, because of his insistence on being trusted by his, my lord, trusted upon him, my lord, he in fact, my lord, paid an amount of rupees, my lord, more than 26 lakhs, my lord, 20,000 to the accused person, my lord. And and he has also, my lord, received, my lord, 2 lakhs from the other accused person. And regarding, my lord, there are matter regarding the non-furnishing of the, my lord, notice, my lord, your lordship may kindly come to page 18, my lord. Although, my lord, specifically, my lord, in some cases we have found what happened, my lord, after receipt of the CD, we have found in many cases that later on, my lord, some sections added for which, my lord, ultimately the, my lord, requirement of section 35(3) of the BNS is not at all required. And in some cases, my lord, although, my lord, forwarding report, my lord, although there is no mention about that particular provision later on in CD, there are sufficient reasons explaining why, my lord, at that point of time 35(3) was not served. And here also, my lord, from the reasons of arrest, my lord, specifically the arrested accused by FRNM accused of this case, my lord, sufficient evidence, all those grounds are, my lord, reasons of arrest specifically mentioned in detail, my lord, why the accused person was arrested, my lord. Now only CD will reveal, my lord, regarding whether, my lord, there are, my lord, any other sections added, my lord, in this case, considering the nature of the offense. Only CD will reveal, my
Your Lordship, the mandatory provision in this case has not been complied with, and regarding that, no mention is being made in the forwarding report that why section 35 subsection 3 was not complied with the investigating agency, Lordship.
Uh,
Lordship, the petitioner is also a
Arrested.
patient of diabetes and hypertension, which he's also a paralysis patient, Lordship. The health
Paralyzed?
issue is also there,
Is
Lordship.
paralyzed.
Yes, Lordship.
So inside detail whether there is any provision for providing him necessary treatment and all necessary medicines were also provided?
Lordship.
Not yet.
Not yet, Lordship.
Not provided.
Not yet, Lordship. His health is deteriorated.
Let's see. Heart rate. Very important call for the case type. The jail authority is directed to provide necessary medicines and treatment required by the accused petitioner, who is reported to be a patient of diabetes, hypertension, and also reported that he is in paralyzed condition. The jail authority is also hereby directed to furnish the medical report of the accused petition on or before the next date of the state. When it can be where from, it has to come.
Paltan Bazar.
Polton Bazar.
He got arrested on 6th of this month.
Yes, on 6 to arrest.
কিবা আছে দিদি লাগে 16th 1/6. We are giving short date. We are also calling for the report for the jail authority.
Lordship. Much obliged.
Please, Your Lordship. Lordship, can you may allow for time being, Lordship?
May I please, Lordship? 483 application, Lordship. I am behind the bar for 36 days, Your Lordship. FI is present 12. The allegation is at 316 subclause 3, Lord. The whole FI, Your Lordship, is not 12, FI. The whole FI is based to accused person Pramananda Yadav and Om Prakash Yadav. I am not neither the Pramananda or the Om Prakash Yadav, Your Lordship. These two persons, the Om Prakash Yadav, he has transported some iron bars, and then he misappropriated, and that he was arrested from Bokista police station, and some iron bars were also seized. This accused person, he took my name, Your Lordship, and I have been arrested from Kolkata. That saying some iron bars were sold to me, Your Lordship. Then nothing was recovered from me. My shop was visited, nothing recovered. Only on the mere submission given by this accused person, Your Lordship. I have been arrested and I am behind the bar about 36 days, Your Lordship. No recovery, nothing is made, Your Lordship. Further detention may not be required, Lordship. I am already 36 days, nothing recovery, only on the basis of this accused person's statement, Your Lordship.
Yes, board.
Okay, grounds of arrest, page 22, my lord. During interrogation, the arrested accused person, namely Santosh Tiwari, confessed that he sold the iron bars to another person, namely Papu. My lord.
No, he sold the iron bars to whom?
One Papu, my lord. Now, who is Papu? Now, my lord, the arrested accused person is only know Papu, who bought the iron bars from him. So, my lord, who is Papu? Only the present petitioner knows. My lord, ultimately, during investigation, it revealed that he sold all those, my lord, TMT bars to someone Papu. My lord. And my lord, he is from driver.
No. He was neither the driver, you know, neither the I was never entrusted this property, Your Lordship. I have a shopkeeper in Kolkata, Your Lordship. This only the mere allegation made by this accused person. I have been arrested and 36 days behind the bar. Really, I have been taken in police custody.
Total value of the consignment is 21 lakhs 38,000. So he is the person who received those stolen articles.
Yes.
It seems. Malad.
Your Lordship, there is a seizure list, Your Lordship, which was made in Gauhati, Your Lordship. She is from the Om Prakash, the owner of the truck, Your Lordship.
And during interrogation, my lord, he himself stated that he sold all those, thereafter all those, my lord, CMT bars to one Papu. But who is Papu during?
So obviously from your shop or your residence, there
recovered.
may not be any recovery.
Page number 24, this is page number 24, seizure list. I have any.
Yes, there may not be any recovery, that's what I'm saying.
Yes,
Because
nothing,
only
only.
it is recovered from these two petitioners.
Yes,
You
Your
other two accused persons.
Nothing was recovered from me, Your Lord.
Obviously, it cannot be any recovery because you sold all these stolen items. That's why. You have already sold to those Papu and then from Papu to these two petitioners. These two other two. That's why there is no recovery from you.
This
Then it
seizure
can
list.
be called. From which Gauhati, Kamrup Metro police station?
Kamrup Metro, Bokista.
18. 18 to realistic it. Proceeding.
Obliged, Lord.
It please, Your Lordship. Lordship may take the anticipatory bail application first.
That is 43.
43. Here the FIR, which the entire case arises out of a counterblast FIR, cross FIR, which we have filed. Earlier, this informant, they have filed this FIR number 183 of 25, where they have stated that these petitioners, along with Rod and Dow, they assaulted this informant with his uncle, and another person was, and some other workers were also involved. So out of that assault, ultimately one of the worker died.
So the section was initially 109, that was converted to 103, 103. 1031. And now on the same day at 10, this earlier incident, that earlier affair, 183, that happened at 11:30 a.m. And the affair
Where
which
is
is,
your FIR?
my affair is at page,
Following you.
page 21. Page 18 will be the typed copy. That affair has been filed by us on the same day at 10:30 a.m. So there, what we have stated in short is that these people, all these nine of them, they entered our shop premises. Then they destroyed some of the items there. And thereafter, to stop that, my mother, Shanti Muni Nunia, she came out and they started assaulting her. Thereafter, one of my sister-in-law, she also came out. So they started assaulting her. So in order to stop all this, we had intervened. So this is a pure act of private defense. Out of that, someone might have got hit, but this is a pure act of private defense, and there was no intention or premeditation. So this 103, this will be diluted.
And their FIR?
And their
FIR lodged
FIR,
by them?
the FIR by them is at page 15. Yes, 13, the type copy.
Lordship.
So here they have named 4 persons.
There are no. Here we are the four
You're
persons.
four.
These people are 9. There are 9
There are
of them.
9 us.
So in their case, it is a case of unlawful assembly, and the lordship will note this also, that in their case there are 9 people. Our case we are 4. So the number game is already more, and that cannot be the probability that out of this entire altercation, this person might have got hit, because if your lordship goes to the FIR as well as the charge sheet, the precise role of the particular accused, that have never been mentioned. So in that regard also, I'd like to submit one.
It is a charge sheeted case.
Yes, charge sheet. Yes, the charge sheet your lordship will find. In the bail application, it has been annexed. The charge sheet. P72 of 25 at page 44. The relevant portion at page 54 of the bail application. May I read from the second paragraph of page 54? Hmm.
You, in AB, how many petitions are there? Only one.
3 petitioners are there in the AB.
Oh,
3, 1, 2, then 3, and the BA, 1 petitioner. So all 4 of them are here. So in the charge sheet, your lordship will find all of them have been implicated, but the precise role that has not been stated anywhere.
absconder.
Yes, shown as that's why we have preferred the anticipation.
What is the stage of the case at present?
Production stage,
Production.
lordship, and lordship, there are eyewitness to this effect, lordship, and moreover, it was a brutal murder, lordship. Not only that, lordship, and there are shopkeepers who have seen, lordship, and one of the informant is informant come injured witness, lordship. Though he has sustained simple injury, but he was an injured witness. So it is not a case for anticipatory bail, lordship, at this stage, because evidence must be taken, lordship, because eyewitnesses are there to the effect. Lordship, I have flagged the scan copy of the eyewitnesses and the PM report, the opinion.
Was in motion stage, it already come.
No, Lordship,
No,
it was
the
yesterday
in the AB,
mentioned,
the
Lordship.
TCR has been called.
TCR was there,
Your
Lordship.
lordship, before that, I have not finished my argument because your lordship, in the FIR filed by them, filed by us, these people have also already been charged, also been charge sheeted. So it is not that we are the aggressor; they were the aggressor, and we are the victims in that case. So this charge sheet also I have brought it for your lordship's perusal.
Now, see, the question is that who is the aggressor at this point of time? It cannot be determined so easily because you have to go through the entire evidence on record, and the evidence is to be recorded. Then only will come to know who is the aggressor. Obviously, undoubtedly, from your submission, you have seen that there was an altercation or quarrel between two groups.
Yes.
That is okay. But out of that, one person died, and from your side was some may sustain some injury.
Yes.
That may not be so good. But one person has submitted that one person was killed brutally by you, 4. So
No, that is
the case.
They were
Yes.
named, all were named.
Similarly, in this case, these people have been named.
It is
So
there.
at this stage, it cannot be determined.
It is not denial fact. It is there. But in the petitioner have already brutally murdered the
Against these 3 accused persons, what is this says at present? They have your is there any warrant issued against you?
That I'm not sure. Against this,
You have not annexed any order sheet here?
for this summons. No order
This
sheet.
is already been charged sheeted. Have you
Yes, it
annexed
has
any
been
order
charge
sheet?
sheeted, but whether I have received any summons, that I don't have the instruction.
Then what to say?
16. Date is fixed on 16 to. Or that is
For
I am
other case. You are for the informant.
informant scheme. Out of the assault, 5 persons were injured, including the informant, out of which 2 were received minor injury and the 3 received serious injury. Out of 3, 1 died in the hospital, 2 still under treatment. I have all
Who's
the
still under treatment?
yes, Lord. I have all the medical documents. I have
Your Lordship, I have also annexed the medical reports. 2 of our persons have
They are
also
not-
received grievous
they
injuries.
heated by Sabul, that is in the charge sheet, it is reflected, and by iron rod.
In
That was
that charge sheet,
recovered
it has been
also by
stated that
petitioner.
they have hit by sharp weapons. Your Lordship will see another thing. In both the cases, different IO has been appointed. So that cannot also be done in terms of decision passed by the apex court.
I think you're placing the AB, no?
Yes.
BA you have not placed
No,
it.
no.
And why you people is to be shown as an absconder? You have not cooperated in investigation?
Because, Your Lordship, earlier we applied for protection, but there was no interim. That's why. And these persons, one of the brother has already been arrested, and the police also came in our house searching for us. That's why.
That is petition number two, Lordship.
He was arrested.
He was arrested.
No, no, no. On the
Rajan-
page. Rajan, oh, here, accused number 2.
No, whether any someone issued, warrant issued, we are not in a position to say yes. It is
Your Lordship can do another thing. Your Lordship can call for the record of this 165 also. 165 of 25 FIR date. FIR number.
The cross case record.
The cross case record. There also charge sheet were submitted on 29/11/25.
it's not committed, I think, or what? Is it committed? Yes.
This one, Lordship.
Huh?
This is Lordship in production stage, Lordship there. As their absconder is there, Lordship.
That means not yet committed.
Not committed because they are not in production. And Lordship, their cases after this first of time, not say at first the petitioner have not filed their FIR, Lordship. It was the deceased, Lordship. Informant.
Lordship will see the time also. Time of incident. Our incident happened at 10:30 a.m. and the next incident happened at 11:30.
But your affair is after
Of course, we have filed the register FIR
it was
letter.
afterthought affair.
Oh, no, how can it be said at this stage?
Okay, I withdraw it.
After paid charge sheet, that is the order. You have also applied for anything before Ranet session judge.
Yes, we applied once.
That is on 10/11. Dinesh. Exactly.
Is one of them applied, Dinesh? Page 38.
Order sheets are not here.
Your Lordship may kindly go through this charge sheet also. Once.
No, I'm not. The filing of the charge sheet case is not put up before the court, or no, it's not here anything.
I can take instruction also if they have received the.
In which before the appearance of the accused person.
On which date?
16 to
coming 16. At least they know the big case for granting a individual bail application. They are avoiding the arrest and they have preferred earlier approached the learned session court that was rejected at the perusal of the SL. Already my learned PP has said the brutally murdered case. By using sabul and iron rod, they have previously injured 3 persons.
eyewitnesses are
there.
So they have named.
In their case.
Named.
And another aspect, Your Lordship, whether
The uncle of the informant received such a grievous injury, his Here it reads 18 seats. The head, forehead.
PM report, it is reflected. In PM, I have flagged the PM report where it is reflected about the deceased lordship, his injury, wounds position lordship.
Another thing, Your Lordship, I would like to argue whether the informant can argue this case.
He's assisting me, he's assisting me.
No, whether he can argue, whether he can submit all this. He does not have the right to submit also.
Lordship, I'll give a judgment I
also have some judgments and also the statute.
Yeah.
Excuse me. This is whether informant can argue or not, Lordship, regarding that. 56 and 57.
Your Lordship, this is regarding informant cannot argue.
It is.
He will not coming to that aspect. We see that it
No.
is assisted by him. Otherwise, we may not make mention of.
Lordship.
Card Mr. as the declarant counsel 43 to 2. As the declarant counsel the petitioner's citizens
You cannot.
and also her.
Thank
Your name has been reflected here.
Lordship.
That's the.
No, Mr. J. Das. So, okay, then we'll record his name. His name is already reflected. But Mr. J. Das, when it was the informant, and it appeared and filed as and MSA bill of internet will be appearing on this application section 7. Scan copy of the petition has already been received. Next, submitted by Mr. Dr. Dilana Counsel for the petition that there was an altercation and quarrel between two groups, wherein the 9 numbers of persons from the informant side had attacked the family of the accused person, and some of them also sustained grievous injury on their person, for which they approached investigation at about 10:30 a.m. the very day of occurrence. They lodged an FIR, and the present FIR against the petitioners were also lodged and counterblast to them say that. However, he submitted is denied that there was an altercation and quarrel between two groups, and both the sides also sustained injury, out of which one person died from homicide. Submitted that these 3 accused persons earlier approached the learned session judge for secretary bail, but as their bail application was rejected, they could not appear before the IO, for which their names has been shown as an absconder in the charge. They are still whenever they are ready and willing to appear before the learned trial court, learned session, learned session, learned trial court, when, as and when the date is fixed, date is fixed or fixed. And the three petitioners are of from this or are from the same locality, and they will provide the sufficient surety if bail petitions for the present petitioners are stated. Well, Mr. Sorry, MS Begum, the learned petition will be submitted in this report. That it is the fact that there was a cross case between the parties, but all the present FIR, all the present petitioners, including one Rajesh Nunia, so brutally assaulted the informant, side, and for which some of the victims sustained previous injuries on their person, and one who died, one
Lordship,
Arun Namasudra.
Borun Namasudra died or died. The party submitted that she was brutally killed by these petitioners, including the other accused mentioned in the FIR. And there are several eyewitnesses also to the incident. Accordingly submitted that this may not be a fit case for extending the privilege of pre-arrest bail to the petitioners who did not cooperate with the IO during the investigation of this case. Mr. Das, the learned counsel for the informant, also submitted in this regard that some injured persons are still under treatment who sustained previous hurt for the said incident. All the accused persons brutally killed the deceased by using the sharp object and other weapons. Accordingly, this learned counsel appearing for the informant also raised objection and submitted that this is not a fit case to extend the privilege of pre-arrest bail to the petitions. Hearing this submission made by learned counsel also against his record and the annexures file along with the petition. The record, it is seen that there was a quarrel between two groups, but it is seen that out of that some of the victims sustained grievous injuries out of the alleged incident. Same time, one person also died for the said incident, and the name of the four accused persons are being uttered by all the witnesses to the case. Further from the submission made by learned counsel and from the record also, it is seen that after reception of their anticipatory bail, they did not cooperate with the IO during the investigation, in spite of the fact that, in spite of the knowledge that the case is pending before them, and absconded during the drug investigation. So, considering the conduct of the accused petitioner as well as the nature of the offense, I do not find it a fit case to extend the privilege of pre-arrest bail to the present petitions. However, the
Lordship, it is blunt object like iron rod and supple.
these are blunt.
Blunt.
Objects.
Iron rod and supple.
Once is good. Pre-arrest bail at stage, however, all the petitioners are hereby directed to appear before the learned trial court with an appropriate application for bail, which may be considered in accordance. As informed, the next date is fixed on 16/2,
16-2.
16/2, and till date, as an interim, no corrosive action shall be taken against present petition. With the above observation, 16/2, we are giving an interim protection. No corrosive action shall be taken, and then you just appear before.
Your Lordship, in the item 42, there I'd like to submit that this petitioner, he is already inside the prison since 136 days, and now the investigation is already over. And therefore, under such circumstances, your Lordship may consider.
Yes, in 42,
Lordship,
Lordship is granting detention till 16.
yes.
16-2, Lordship, they will appear.
That may be specific after that.
No.
No, in regard
In
to
regard to
42,
42, what do you want, sir?
43.
42.
42.
42.
Yes.
Lordship, in 42, Lordship, this accused person, Lordship, in the forwarding, it is mentioned itself, Lordship, the accused person have a previous criminal record in the year previous 2018, Lordship. So it is not fit to grant as is a search-sheeted, Lordship. Let the trial be started because he was the main Lord. He was there, Lordship.
So what is the use of keeping him inside the custody?
Lordship, because
Everything
none
is
of the
there.
witnesses are still now. It is not yet committed. Let the case be committed.
Ready to
Then,
cooperate
Lordship,
otherwise.
no, Lordship, not at this stage, Lordship, because one person is
Everything
already
they have
died, Lordship,
objection.
and it is
That is the
substituted. Let the witnesses be prosecuted.
All the witnesses' statements, that is also over. What remains
No, it
to
is
be done inside the
started.
judicial custody?
They have in 2018, Lordship, they have attempt to set fire to the police station, Lord. This accused person. It is in page number 18 of 42, Lordship. The forwarding report, Lordship. The present petitioner, Lordship, who is behind the
police station.
police station.
In that regard, do you want to sir?
In that regard, I will not submit anything. Only in regard to this case.
Article 42 instead of same. It is submitted by Mr. The present accused petitioner within custody since last 100. How many days?
136 days as on.
136 days, and 36 days in custody, and case has already been charged after completion of the investigation. And hence, at this stage, there cannot be any question of tampering with the investigation if the accused petitioner is released. However, he is he will appear before the learned trial court below as and when the date is fixed, and will contest the case. He is the permanent resident of this address locality and will and hence there is no chance of absconding. Rather, he will provide sufficient surety for to the satisfaction of the court. Next, MS Beckham, the learned petition PP submitted in this report that one person is brutally killed in the present case, wherein the present accused petitioner is also involved. Several eyewitnesses to the execution, and hence there is possibility of tampering with the witnesses if the accused person is released on bail. She further submitted that the accused petitioner has the criminal antecedents, wherein it is stated in the following report that in the year 2018 itself, he, along with some others, also tried to set fire in the police station, and thus the accused person is a very accused, and hence at this stage, if he is released on bail, there is probability of tampering with the the witness, especially the eyewitnesses. Next para, hearing the submission made by learning consequences. I have also filed the case report. And from the following report, itself is seen that accused petitioner has other criminal background, and he tried to set on fire. They tried to, in page number 18, you are saying, no?
Lordship.
That's what I tried to set fire to the Nivea NIVIA WP in the year 2018, for which also he was forward arrested and forwarded before the court below. Learned court below. Further from the record as well as from the case diary, it is seen that but it could not be committed at this stage, huh? Not yet comes.
Not committed. As they were absconded.
As the probability of tampering with the witnesses of the prosecution as submitted by the learned additional people also cannot be outrightly rejected at this stage, considering the nature of allegation as well as the previous conduct, the criminal antecedent of the present accusation. In view of this, I do not find it justified to allow the bail application at this stage and same as rejected. We are rejecting you at this stage. Let us see at the later part.
Obliged.
Obliged.
Quite well. তাহলে ইহঁতে দিয়া আমার রেকর্ডে
May I please, my lord? But this is a regular bail application, my lord. Lordship will kindly find the FIR at page 12.
page 12.
Page 12, my lord, is the translated portion. The allegation is that, my lord, may I read? With due respect, Lordship has found. With due respect, I beg to state that on 14/1/2025 at around 2 a.m. in the morning, the below described 7 numbers of cows, cattle were stolen by some unknown miscreants. The FIR is not named, it is against unknown miscreants from my own cow shed. With regards to that, I am lodging this FIR. The description of those cows have been given. Now, I am not named. I have just, Lordship will kindly come to page number 21. That is the scissor list. What happened actually, my lord, I am a farmer. I purchased these 4 numbers of cows. Page number 21 is the scissor list. I purchased these 4 numbers of cows from another person, my lord. And these people, I don't know either they have been taken into custody or not. I purchased this from one Shahadat Ali. And on that ground, my lord, the police have seized my these 4 cows. And Lordship will kindly mark the date. The date of seizure is a 16/1/2026, my lord. Now I will request your lordship. There are 2 seizure lists, my lord. One is page 21 that dated 16/1/2026, seized from me. And there is another seizure list, my lord. Lordship will come to page 22, my lord, dated 19/1/2026, not be recovered is seized from some other person. So Lordship will kindly come to page number 24, my lord. This is my rejected bail application. My bail plea was rejected from the SDGM Petrol. For hearing, my lord, the second paragraph, after peruse the case records. It says that now from the case records, it appears that 2 numbers of cattle were recovered from the possession of the accused persons. I was also accused. Now the seizure list was from 16/1/2026 and 19/1/27. We'll call it a mistake from the investigating agencies that they have not submitted. They might not have submitted that. It says that 2 numbers of cows. On the other hand, my lord, there are 7 numbers of cows were stolen. Already 6 were possessed, seized by the investigating agency. But it says
How many numbers of cows are seized
7,
from
my
you?
lord.
From you?
From me, my lord, 4. I purchased it from one Shahadat Ali that was seized from me. And on this ground only, the lordship will kindly come to the the third line, last third line. Further, all the stolen cows are not yet recovered. For only on this recovery, my lord, my bail was rejected. Now, had that seizure list been produced, my lord, I would have granted, the court would have granted me bail because the section is 305 clause A. It is, my lord, I'm 25 days in custody. Nothing will, since it has been recovered, mal, nothing will come out from my position as of now. Mal, I may be granted bail. I cannot evade the process of law. I have to face the trial. I will, in any condition, my lord, at this point, 25 days in custody, my lord. Everything has been recovered. 6 numbers of cows have been recovered out of 7, my lord. And I'm also not named in this FIR. My lord, kindly my interim may be considered, my lord. Although in the admittedly 4 cows were recovered from the person of the present petitioner, seizure list is available. And regarding that, in the trial court order number, 2 numbers of cows recovered from it, that may be a inadvertent mistake. Otherwise, admittedly 4 cows recovered from the present from the position of the present petitioner. And regarding length of detention, till now, other 3 cows were not yet recovered. All the cows were not yet
Pointing out
length of
two
detention.
seizure lists.
There are
One is from him, for where from 4 cows. And in page number 22 also he is citing 22. In 22,
one not yet recovered, total 6 recovered.
6.
6 recovered. 6 total 7 have the length of the thing.
You are Mr. Ahmed?
SS Ahmed, my lord.
Pardon, Mr. SS. Done it also for the petition. And also for Mr. Done petitioner PP at the one account. It's an application of sections. And it's next part submitted by Mr. Ahmed. This petitioner is he has not committed any such offense as a media. He purchased 4 numbers of cows from one Sahadat family. And police, on the basis of information, had seized 4 numbers of cows from his possession on 16/1/2026. In the same time, he also shows that by another seizure list on 19/1/2026. 2 other numbers of cows are being seized from possession of another person. And thus, still now, out of 7 numbers of stolen cows, 6 has already been recovered as per the seizure list. But it is submitted that accused is in custody since past 25 days, and hence his conduct to the interrogation may not also be necessary for purpose of investigation. However, being the permanent resident of the addressed locality, he will there is no chance of responding. Rather, you will obtain his cooperation in further investigation. Next part, Mr. Waterford shall be submitted in that that 4 numbers of cows are already seized from his position, And two numbers of cows are also seems to be recovered from possession of, but he is not the present, but his involvement of the present petitioner cannot be denied at this stage, and the CD will reveal the actual fact of the case, and accordingly he insisted to call for the case. Next, during the submission made by the obstacle space, all other aspects, including the recovery of the student cows, as well as the period of detention already undergone by the extradition, and find that further custodial interrogation may not be necessary for the purpose of investigation. In view of this, the present accused petition is allowed to go on bail. This case is of which
Bogribaari police station.
it is under which district?
Dhubri district. No, Kokrajhar, my Kokrajhar it is.
Kokrajhar? Bogribaari falls under Kokrajhar or Dhubri?
It is given Kokrajhar, my lord.
Kokrajhar. CTM
District subdivision of Kokrajhar.
Dhubri or Kokrajhar? Because
Dhubri, my district.
Bogribaari. See this? No, Kokrajhar.
Kokrajhar, yes, Kokrajhar, man.
But it will be SDGM as Kokrajhar means CGM Kokrajhar.
Kokrajhar, yes.
CGM.
Brothers, my lord, had taken money for investing purpose, my lord, from the informant lordship. On demand, that was not given lordship. Return lordship. Kindly see the FIR at page 8 lordship. My lord, translated copy is at 8 lost. My lord, three brothers, Jahangir Alam, Ashadur Rahman, number 3, Sajidur Rahman. My lord. I am the petitioner is Sajidur Rahman before your lordship. He is my lord, a contractor, my lord, registered contractor, lordship. My lord, now against him specific allegation that the second and third accused persons claim that they were involved in government and private contract work both inside and outside Assam. On the pretext of the group's savings and investment, the accused persons took a total of rupees so and so in cash from me. Currently, the first accused is in hiding. When we went to demand our deposited money back, the second and third accused, along with other family members, issued various threats. This is only this allegation, lordship. Well, absolutely civil matter. If money is not returned, I'll go for civil suit, lordship. Why criminal case, lordship? While 40 days in judicial custody, he was, my lord, thoroughly interrogated, my lord, then put in jail, my lord. Now, suddenly on 7/2/2026, lordship, his health condition was deteriorated. Then he was, my lord, admitted, taken to the, my lord, Nagaon Civil Hospital. Thereafter, my lord, 2 times he was taken, my lord. Kidney patient, he has now severe problem, my lord. I have stated in paragraph 8 of the, my lord, documents could not be collected because this is in the hand of the jail authority, lordship. So at this stage, my lord, whether custodial further interrogation is necessary, my lord. 50, my lord, 60 days offense, lordship. Today is 40 days, lordship. Civil nature case, lordship. In my humble submission, my lord, further custodial interrogation may not be necessary, my lord. Already, my lord, thoroughly interrogated this document. Even a case is made, there is a document based on documentary evidence, lordship. I am not a member of any group, self-help group, lordship. Number 1 is the member of a self-help group, lordship. I am a contractor, my lord. Kindly see the license, my lord, at page 15. My lord, allegation is that for the purpose of investing, my lord, money was taken, my lord. Huge money, 6 lakhs, my lord. Where from the informant got, lordship? How, my lord, cash amount was transacted, lordship? This is not permitted. 20,000 is only rupees 20,000 is permitted, my lord, for cash transaction, my lord. This is absolutely false allegation, lordship, my lord. What is the source of income of the informant, lordship? That is not disclosed in the affair, lordship. Where from it was, my lord? So apart from the, my lord, allegation, whether it is true or false, lordship, the further custodial interrogation may not be necessary, lordship. At this stage, my lord, may be allowed to go. We will go take further treatment, my lord. And in Nagaon civil hospital where he was taken, lordship, there is no proper equipment for kidney treatment, lordship. I have stated in paragraph, my lord, 8 of the petition, petition law.
My lord, forwarding report is at page 13, my lord. Till now, total 87 affairs has been lodged against the present petitioner along with the accused person. He, along with his, my lord, brother, my lord, created self-help group and collecting huge amount of money from the public. Your lordship may kindly come to page, page 13, my lord. There is total 87 numbers of FIR filed against the accused person for their SD till now. 87 numbers.
There is total file against the accused persons. Accused persons, lordship. I am not my lord. The 3 persons there, 3 brothers are there, my lord. Specific is not there, lordship. Whether against me or not, lordship. Only because of family members, my lord. Against all three brothers, lordship. My lord, FIR was lost, lordship.
Those are victimized.
87 FIRs is not a matter of.
Yes.
Not against me, lordship.
My lordship is
already 40 days, lordship. 60 days, my lord, offense, lordship. Only, my lord, one offense is, my lord,
in fact, bail petition is liable.
Non-bailable, lordship.
Already, my lord, he has, my lord, he along with his brothers, my lord, till now 87 affairs lost by the victimized person. So, my lord, if city comes, my lord, what will come, my lord, that will definitely, my lord.
Then, my lord, so
forwarding
40 days
report
already,
itself, my lord, this petition is liable to be rejected at this stage.
Already 40 days in judicial custody,
Otherwise,
lordship.
in case of calling CD, my lord, in this type of offences, my lord, otherwise investigation will be hampered.
On the other hand, lordship, he was suffering from, my lord, kidney problem. This is not, my lord, this serious problem, lordship.
How? What is the symptom? What kind of problem he is suffering?
I have stated in paragraph 8, lordship.
No. What kind?
Fine. Paragraph 8, lordship, with the petition, bail petition, lordship. On 7/2/2020 at about 5:30 p.m., 3 p.m., the petitioner suddenly suffered from serious health complications relating to his kidney condition, due to which his health was deteriorated. In view of the medical urgency,
I agree that kidney patient may be there, but I don't know what kind of. It's not here anything.
my lord, the document was not provided to the family members, lordship.
According to the counsel for the but Mr. P. Swenson, it is submitted by Mr. Rahman that the present accused petitioner is innocent, and he basically is a contractor in the government department. He is not a member of the good, as no member of the any self-help group as mentioned in the app. Also, he is a kidney patient, and he is on 7/2/2026 also his health condition was deteriorated, for which he had to be taken into Nagaon Civil Hospital, wherein also there is no property could be provided due to absence of any specialist. He is in custody since last 40 days, and hence, considering his length of detention, he may be released. Next one, Mr. Bott will run a BP submitted in this report. It is a very serious nature of offense, and from the forwarding report itself, it is seen that this is not only a single FIR against the present petitioner, but there are 87 numbers of FIRs so far pending against the present petitioner along with the other accused person. And accordingly, Mr. Bott submitted that considering the nature of the bail petition may be outrightly accepted. Next product, without passing any order instantly, find it necessary to pay the case diary, and accordingly the CDB called for fixing he is in custody for 40 days later reopening. Nagaon. he is in custody for 40 days, so
Yes,
take
yes.
a date. So
Then
that
my lord on 23 to,
is it on 20,
yes.
My lord,
20 Swen Security. Further, the jail authority is hereby directed to provide a necessary treatment for the accused petitioner as required. And apart from that, the jail authority is also hereby directed to provide the health status report of the present accused petitioner on or before the next date of list account.
My lord, on 17 to 2026, my lord, CD was called for in another AB lordship 131 of 2026.
17 to.
Yes, lord. On 17 to,
Just tell us the number.
my lord,
17.
AB 131 oblique of
AB?
2026.
AB
AB
1.
131 of 2026.
Oh. List the matter along with AB 131 of
In that case, interim protection is there, lord.
for
17 to lord. My lord, court lordship, right now, my lord, I'll inform lordship. It was fixed on 17 to 2026. Court postponed. Sorry, lordship. My lord, I am verifying, lordship. Lordship, this is our Honorable Justice S.K. Sharma, lordship.
you know. Okay. Okay.
Lordship, obligor.
Gawin pa nagbrito pa. So kung iman ako ng powers. Strongly say good order. So the
Lordship,
yes.
this is an anticipatory bail application.
Yes.
The alleged section is of theft. So the FIR is at page 13 if you're not confused. The short FIR. Yes, Lordship. 1-3. Shall I read the FIR? I had the honor to report that Mr. Shahidul Alam, the operations manager at the Mandu, the Escape Resort, has been missing since the morning of 6/1/2026. He went to deposit an amount of 4,60,948 rupees on 6/1/2026 into Mandu, the Escape's bank account at SBI branch Kohara, and has been absconding since then and is unreachable through any means since then. It has been confirmed that he has fled away with the aforementioned amount 4,60,948 with the intention of committing a fraud. Hence the case. Now, Your Lordship, the actual fact of the case is that the petitioner is an employer at the aforementioned resort at the post of operations manager. We have also stated in paragraph 5 of page number 4. So here what has happened is the petitioner has a prior 15 years of experience in this profession, and he has no complaint from any of the previous owners or places that he has worked at. So when he approached the said resort for his employment, he was expecting a handsome salary since he has a considerable of 15 years of experience in this profession, and his salary was fixed at 60,000 per month. So only on one, there is a condition from the informant side that half of his salary will be official and the other half will be unofficial due to some personal reasons that the informant has. So what led to the lodging of this FIR is that since the last 6 months, the petitioner was not being paid the entire full salary. Only half of it was being paid to him. So he made multiple requests to the informant to clear his remaining dues, and the informant did not pay any heed, as a result of which this FIR was lodged. So I would like to highlight a certain point here that if at all somebody steals such a huge amount from me, considering it is 4,68,000 something, so will I wait for another 14 years to lodge in complaint? As there is a 14 days of gap. The incident occurred at 6/1/2026 as alleged by the informant in the FIR, whereas the FIR was lodged on 19th of Jan. A gap of 14 days is there. So my only humble submission at this stage is that CD may be called for Meanwhile, my prayer for interim may be allowed.
Yes, your lordship may consider, but my lord, regarding officially he has taken in 30,000 and unofficially 30,000. This is the difficulty. Why he has fixed that, my lord? My lord, through account pay he received 30,000, and by case he received. Now he has stated that his actual, my lord, salary is 60,000. So the owner has not paid that amount. My lord, probably he has committed that mistake thereafter, my lord, because till now he is absconding. Otherwise, my lord, official and unofficial part, my lord, that cannot be accepted. Story cannot be accepted. Anyway, my lord, let him appear.
ADAS,
P. Bora, Lordship. I'm appearing on behalf of Ms. Adas.
Pardon, Peter P. Bora, appearing with Mr. Mr. P. Bora, Illuminate. Then application. Next one, considering this. Find it. I find it justified to provide interim protection to the present petitioner till receive his time, so that he can appear before the tribe and can record his statement. Okay, you'll be under interim protection.
Deeply obliged, Lordship. Next.
Next,
5th of March, 25.
5th of March.
Obliged, Lordship.
নিগলকে প্রিয় প্রবন্ধ দেখা প্রোটোকল জানিস
May it please your lordship. My lord, the petitioner before your lordship is a woman officer of the State Bank of India. Presently, she is posted in Nagaon. My lord, while she was in Mirja, my lord, it was during the period from 1/2/2023 to 17/4/2023. That is in the year financial year 2023. From the period 1/2/2023 to 17/4/2023, there were certain anomalies noticed by the bank. Then when those anomalies were noticed by the bank, my lord, a disciplinary proceeding was initiated. Your lordship will find that at page 22. I'll come to the FIR because the FIR is subsequent. So at page 22, your lordship will find that the disciplinary proceedings was initiated on 9/9/2024. And I was asked to submit my written statement of defense in terms of page 2022. Then your lordship will find on the culmination of the page 23 is also, my lord, the initiation. Charges are at page 24, my lord. Page 24, your lordship will find the article of charges, my lord.
Yes.
Your lordship will see during her tenure as field officer, that's referring at our Mija branch on 1/2/2022 to 17/4/22, certain serious irregularities in total disregard to the bank systems and procedures were alleged to have been committed by her, and due to such irregularity, bank has suffered a reputational loss. So they are talking about the reputation loss and no financial as such was detected. Then 25, 26 and up to page 29 are the different charges. Then the penalty was imposed, your lordship will find at page 29. Second paragraph, my lord. Page 29 is the penalty imposed. After examining the matter carefully, going through the case in its entirety and taken into consideration, your lordship got it, my lord.
And considering the consideration, the contents of your submission, and after having applied my free and fair mind, independently to the full facts and circumstances of the case, I am the considered opinion that inch of justice would be made if you are imposed with the penalty of reduction to middle management grade. क्या होगा? Middle management grade scale 2 to grade from middle management grade scale 3. From 3, she has been demoted to 2 and fixed the salary at 64,820, and all those penalties was imposed, and she said that she will only be entitled to the promotion after completing the qualifying service. Against that matter, we filed an appeal. The appellate order starts at page 30, and the appellate order also concurred with the finding of the disciplinary proceeding that your lordship will find the final order is at page 48. Basically, it concurred with the finding and says that the bank may suffer loss. These are all estimation. And at page 49, my lord, I have given the examination routine. One of my son is appearing for his exam, the CBSE. This is going on, and I have a second son who is just a child. So, and the after, my lord, your lordship will find this appellate authority's order is dated, my lord, 26th of August 2025. Now, my lord, after all these months, my lord, they have now filed this FIR at page 20. Page 20, my lord, your lordship will find the FIR. They have given the names of the borrowers, names and all. Some of the borrowers, my lord, it appears that they were sanctioned loan, but they had given some documents which they are not genuine, or the suspected not to be genuine. They have given the limit sanction and all. But nowhere it is said that it is that any pecuniary loss as such has been submitted by the bank. So my respectful submission today is that since it is the whole case is based on documentary evidence, and one inquiry has already culminated, all the documents is in the possession of the bank. Secondly, the offense which took place in 2023 was at Mirja. Today, I am in Nagaon, and I am still discharging the duties in Nagaon. They have attached me to a section. So there is no question of my abscondence or tampering with the evidence which is at Mirja. Well, your lordship will call for the case diary. Since my lord, considering my present situation, your lordship will grant me an interim till my son's exam is over. After that, if your lordship finds that looking into the case diary, my custodial detention is required for the nature of this type of documentary evidence, then your lordship will kindly consider at that appropriate time. But today, your lordship will consider the precarious situation I am, and the bank has seen, your lordship, what penalty they have imposed, which after considering by all their technical experts. So my humble submission is that till the case diary is produced, your lordship will protect me so that I can look after my son in his exam. Otherwise, that will also affect the child and all. But after case diary, if your lordship finds that my custodial detention is required, then your lordship may pass appropriate orders, madam. And I'm willing to cooperate with the investigation, madam. I'll not. There's no question of abscondence. I'm still in the service of the bank as in the Nagaon branch in the SBI Regional Business Office, Nagaon.
Your lordship may first come to page 27. I will also come to the FIR, my lord, because this is there are serious. This is not a serious economic offense, my lord. Your lordship, I would like to point out regarding pecuniary loss of the bank, my lord. There is not only my lord, harm and reputation of the bank was affected, my lord, but the pecuniary loss suffered by the bank. Page 27, my lord. Total value 1,02,52,200. Plus interest.
No, your lordship will see likely to suffer. There is no finding in the inquiry report that the bank has suffered a loss.
And thereafter, my lord, page 47 regarding manipulation of various documents of the borrowers, and thereafter, my lord, the loan granted, personal loan granted to some of the fictitious borrowers. But even some of the, my lord, from the FIR and my lord, after going through all details, my lord, it can be. It reflects that, my lord, those are actually borrowers are not actually serving in any OP. They are not the service holders. Their documents were manipulated, and even their, my lord, savings bank accounts were also not checked. Even those, my lord, some of the credit notes, by showing some credit notes, they are not the, my lord, employee of a particular my lord, department or any, my lord, office, my lord. Because the loan, the personal loans, my lord, the documents, the bank authority has to, my lord, scrutinize is the, my lord, salary slip and other documents, and only that he is a, my lord, employee of a particular department, is a service holder, then thereafter, my lord, loans can be provided to those, my lord, borrowers. Without, my lord, manipulating all those records, all those documentary evidence, my lord, loans were provided to the borrowers, and ultimately bank has suffered huge financial loss, my lord, loss more than 1 crore. My lord. And my lord, regarding that departmental inquiry, my lord, that search sheet submitted, my lord, department inquiry whole, my lord, thereafter appeal also, during appeals also, my lord, he was degraded, my lord. Those are aspects of that departmental inquiry. But regarding criminal offense, my lord, it cannot be said that only because in the departmental inquiry held, he was, my lord, degraded, that, my lord, criminal offense cannot go on, because these are, my lord, serious economic offense, my lord. These are offenses against the state nation, my lord. So there is no bar in continuing with the investigation, my lord. And
No, we are not against the investigation.
Regarding, my lord, there are material, my lord. These are serious. And on the basis of manipulated documents, he is involved in providing personal loans to the borrowers, my lord. And during, my lord, investigation of during departmental inquiry also, my lord, it revealed that those documents are manipulated. So, my lord, ultimately, the contents of the FIR, it in fact, my lord, corroborates, my lord, my lord,
What is it?
these are-
Well, look, so far,
considering all the
so far I am concerned, Malad, I am only a field officer. There, the service manager is there and the branch manager are there. This pecuniary losses is the only the estimation of the bank. There is no finding in the departmental inquiry or that the bank has suffered a loss. Only the problem with the field officer is that there is lack of due diligence that they have brought. That's why I have been demoted. The sanctioning authority is the branch officer and the service manager who looks. And none of these officers have submitted the document. Documents were submitted by the individual borrower, and they are repaying the loans and all. It has not even become NPA or something like that. But to get those loan, those borrowers have given. Of course, the bank should have been more due diligent in examining those documents, whether those documents were genuine or not. But that lapse is there. And for that lapse, I have been penalized. And today, my lord, only I am seeking that an interim.
What the FIR says, FIR.
FIR, your lordship, page 15, my lord, your lordship may kindly come to page 15.
Page 20 is the relevant portion.
Oh, yes.
20.
Yes, my lord. 20.
20, my lord.
Page 20 regarding, my lord, his status, your lordship may kindly come to page 21, my lord. He, at that point of time, he was the branch manager of that, my lord, Mirja branch.
No, I was not the branch manager. I'm only a field officer. Branch manager is different person. And you'll also will find the details of those persons at the next page. Juridas Kumar is posted as field officer at the material time. Mofidul Hussain posted as service manager at the material time. Minal Das posted as branch manager at the material time. And you'll also will find at the top paragraph, hence the official did not appraise the loan proposal with the required due diligence. You'll also will find at the top, hence the official did not appraise the loan provision with the required. So the whole case, Malad, is based on documents, and the bank financial experts have examined and they have imposed the penalty. There is no pecuniary loss to the bank, Malad. But forget about it, all these things, Malad, today, Malad. You'll also will only consider that I have a child who is appearing for my exam. There is no chance of abscondent because the bank has not put me or terminated my service. I'm still in service of the bank. So, and I'm in Nagaon, and the offense took place in Mija in 2023. And after all this 2023 offense, my lord, they are lodging the FIR in 2025. So, my lord, another 2 weeks, I think, my lord, they can wait, my lord, till the case diary comes, my lord. Because the exam will be over by, my lord, on 10th of March, my lord. 10th of March is not even applicable to me, my lord. It will be over by 9th of March, I think. 9th of no. 7 March or 6 Telugu, Russian. 7 March, I think, social science, then one foreign language or MIL, then French. French, I think, will not be applicable. Mine will be over on 7/3/2026, my child exam, my lord.
Parties should be Learned Senior Assistant by Miss M. Namaste.
That I'm also.
So heard Mr. P. Botwood, Learned Additional PP. It's an application section students. It is submitted by Mr. P. Bott, that the present accused petitioner was earlier faced the department proceeding when she was posted in Jabra from 1 to 2023 to 17/4/2023, wherein the bank had noticed some anomalies in some transactions. Thereafter, the charge was accordingly framed against her, and penalty was also provided in the department proceeding. And against the said penalty, they have also approached the authority concerned with an appeal, but in the appeal also, the order remains same, and she was demoted from grade 2 to grade 3 officers. At present, she is posted as a field officer in Naga. If further submitted, there is no such mention about the financial loss or transaction in the FIR as well as in the departmental proceeding which she already faced. Mr. Court submitted that the son of the petitioner is also appearing his higher secondary examination, and considering this aspect also, she may be protected with some interim protection so that she can appear and extend her cooperation with the police court. Next. Mr. Portakut learned PP submitted in this regard that from the FIR and as well as the other annexures, it is seen that there are huge pecuniary loss more than 1 crore 50 lakhs, and it is also alleged that she manipulates some documents and they also add in some fictitious borrower who are also not the government officials. It is a and the present petitioner is involved in the in that context. Mr. Bond, learned senior, submitted that the present accused petitioner was discharging her duty only as a field officer, and two other persons were working as a strength of the service manager and the branch manager. As a field officer, her only duty is to see the borrower at the and it is the duty of the other bank officials to verify the documents before providing any loan to any person. If further submitted that the present petitioner is not yet terminated from her service and she is still discharging her duty as a field officer from North State.
Well, no, I am not now a field officer. I am a support officer, financial inclusion team at SBI Regional Business Office, Nagaon. Support officer in financial inclusion team, SBI Regional Business Office, Nagaon.
Financial support service. The intersection made by learning the sites, and I find that one opportunity may be provided to the petition to appear fully and to extend her cooperation in further investigations. Further, it is seen that as she is presently posted at now, the entire official records are not in her possession, and is still under position 3. Accordingly, it is provided that when it can be duly under interim protection.
Yes, well, on 10th of March.
And
God bless you.
to be certain conditions about the
Yes.
May it please your lordship.
May it please your lordship, I am appearing on behalf of the petitioner. This petition is filed challenging the registration of FIR dated 29/1/2021 in correspondence with PRC case number 533 of 2022 under section 448, 294, 427, 506 IPC. The brief facts of the case is that on 29/1/2021,
Search sheet already submitted. Search sheet, please.
yes, your order. The respondent number 2 on behalf of one Arindam
just
Datta.
a second, this is already a charge sheeted case. So
Yes,
do you
lordship.
have any prayer for this washing of this charge sheet also? At present, I don't find any.
Yes, lordship. This case is
prayer is
actually it is a civil matter, lordship, and as a counterblast.
No, we are not on that. Mr. Borthakur, the additional PP is submitted that case has already been charge sheeted as per his information. Is there any prayer?
No, lordship. My prayer is regarding quashing of the PRC case number 533 of 2020.
Criminal petition, ma'am. Sorry, ma'am. Criminal petition.
Oh, it's a criminal petition.
Criminal petition.
Oh, acha. And then what? Yes. Then what happened?
Lordship, on 29/1/2021, the respondent number 2, if your lordship kindly see the FIR that is in page number 18 marked as Annexure A.
Page number?
18.
18.
Marked as Annexure A. The
Yes.
respondent number 2 on behalf of one Arindam Datta, who happens to be the brother of the petitioner, he lodged the FIR before the officer in charge Silchar police station alleging that on 28/1/2021 at 8 am the petitioner came to the stockyard of the said Arindam Datta at Balugram and damaged smashed the entire barrier of their bitumen dump on 29/1/2021. Later on, your honor, the same was charge sheeted and registered as PRC case number 533/22 under section 448, 294, 427 and 506 IPC. Lordship, on receipt of the summon, the petitioner appeared before the court and contested the case on court bail. And during the course of the trial, the learned additional public prosecutor also submitted a petition under section 321 CRPC for withdrawal of the above case. But the learned JMFC below arbitrarily held that on perusal of the case record, along with Ejahat charge sheet and other relevant documents available on the case record, it reveals that section 506 part 2 of the IPC is there in the instant case. And and it is in contravention to the government notification dated 21/10/2022 and rejected the withdrawal petition filed by the learned APP and fixed the case on 9/2/2026 for evidence. Lordship, the stockyard dump, as mentioned in the FIR, is actually a part of government khas land, which was illegally occupied by the said Arindam Datta, under whom the respondent number 2 works as a manager. The said government khas land is a playground used for sports and other activities. And against such illegal encroachment and illegal construction, the members of Udayan Sangha, that is a club under District Sports Association Silchar, the petitioner is also a member of that said club. They filed complaint against the said illegal encroachment to the Deputy Commissioner and Silchar Municipal Board on 28/1/2021. That is marked as Annexure F in page number 30. Your Honor, this date is very important. This complaint was filed on 28/1/2021. And as a counterblast to such complaint, the respondent number 2 filed this FIR on 29/1/2021, the very next day after the complaint was filed. Lordship, as a counterblast, the said Arindam Datta through his manager, that is the respondent number 2, filed the FIR on 29/1/2021 against the petitioner just to harass him and cause unnecessary difficulties with an intention to compel the petitioner and the club members to withdraw the complaint petition submitted before the Deputy Commissioner and Executive Officer Silchar Municipal Board. Lordship, in this connection, the Assistant Settlement Officer also issued a report dated 26/4/2021. It is marked as Annexure H in page number 32 and submitted a report stating that there was no any plot of land allotted to Sri Arindam Datta. The complainant...
What is the report? What is the report?
The report is in page number 32, Lordship.
No, what the report says?
The report says that there is no any plot of land allotted to said Arindam Datta at Malogram area. And the complaint was also registered as case number 686 of 21, and the executive officer SMB by memo number so and so dated 14/7/21, that is in page number 33, your lordship, marked as annexure I, asked the said Arindam Datta to demolish the illegal construction structure within 24 hours from the date of receipt of this notice. An application was also submitted to the Deputy Commissioner Kachar on 15/3/2021, lordship, that is marked as annexure J in page number 35.
What had happened after the order of removal of such unauthorized construction? Is there any?
He has preferred an appeal, lordship, and he has also filed a separate title suit in that regard. I have also annexed the plaint of the title suit and
filed
the
the title suit? Who filed?
The employer of the respondent number 2, Arindam Datta, he filed the title suit. That is pending in the competent court of civil, Your Honor, civil court, Your Honor.
So what is their claim? How they are claiming on that land?
Their claim is they have no claim, lordship. In the plaint also they have just mentioned.
Claim. That's why they have preferred in the title suit also.
Lordship,
in the title suit, what is their prayer? What they are claiming?
Lordship,
Because they have some claim over the property. Otherwise, they would not approach the civil forum.
that is absolutely a civil matter, lordship. But as a counterblast, they have filed this FIR.
No, what is their claim? What they are claiming? Any right title over the property? What they are claiming?
Yes, lordship. I am coming to it. They have claimed decree declaring possessory right and of the plaintiff over the land.
Possessory right.
Possessory right, lordship. But the land is a government caste land, and in such regard,
What is
already
the stage of the case in the proceeding at this stage?
it is in evidence stage, lordship.
It is in evidence stage.
Yes.
So why you have come at this stage? It is
Lordship,
already in the evidence stage.
No, lordship. Since a civil matter is already pending.
No, not civil matter. It is criminal matter.
Criminal matter, lordship, it has been pending in evidence stage since long back, lordship. They are not appearing before the court and to produce any evidence.
That's what I am asking. You are seeking the quashing of the entire proceeding.
Lordship,
but why
yes.
have come so late? Why you have come at this stage of evidence?
Lordship,
why not early?
Recently, when the public prosecutor has submitted a withdrawal petition, and recently in the month of September, the withdrawal petition was
Only
rejected.
after filing of the withdrawal petition you have come.
Lordship, yes.
Why?
Lordship, my contention is that this is completely civil matter, and as a counterblast of the complaint dated 28/1/2021.
If it is a supposed civil matter, completely maybe a civil matter. From your submission, it seems that there is some civil dispute. So my question is that why you waited for the evidence to be in the trial stage before the trial commenced? Only you have come to this court only after the rejection of the withdrawal prayer filed by the additional PP. Then only you have come. So that's what I'm asking. Why you're so late? Yes. What happened?
Otherwise, page 29, matter is fixed for evidence on last 9/2/26.
29.
Yes, page 29. His withdrawal petition filed by the learned PP was rejected because offense under section 506 part 2 for which punishment is extend to 7 years. And thereafter the matter is fixed for evidence on 9/2/26. Now, my lord, while
Lordship, in
scan copy of TCR may be called for at least.
Lordship, in para number 6 of the plaint, it can be seen that they have mentioned the employer of the respondent number 2 has mentioned that on 28/1/2021, during watching the CCTV footage, it was observed that the plaintiff, by the plaintiff, that the defendant number 6, that is the current petitioner, is having surreptitious movement near the stock of the bituminous product kept in a portion of the suit land, which is necessary for his contractual work. On the CCTV footage is only capturing his movement. Later
so
on,
who is Dilip Dhar? He is not he is working under Arindam.
He is working under Arindam. Arindam is actually the brother of the petitioner. They have a civil
Brother
matter
of the
going
present
on.
petitioner.
Brother of the present petitioner. And since there is a civil matter going on, he has filed this FIR as a counterblast, lordship, which is why I have prayed before this court to quash the PRC 533 of 2020.
But civil matter is pending Civil case is pending, filed by Arindam, but not by you, na?
No, no. Civil matter has been filed by Arindam Datta
That
because
is filed by him only.
yes, because the ASA report, the report of the municipality board, they have all
Your
gone
good
against
name?
me. My good name is D. Dev, Lordship.
D. Dev. Hard Mr. D. Dev. Then it comes to the petitioner also. Mr. P. Additional PP apprehended. It's an application. So it's expert submitted by Mr. Dev. The learned conflict for the petitioner that the present petitioner is innocent. However, the case has been an FIR has been instituted against him by the respondent number 2, who is an employee of under one Arindam Datta, who is the own brother of the present petitioner. He further submitted that said Arindam Datta was trying to illegally encroach the land, which has been mentioned in the FIR, for which they had the present petitioner along with some local person made a complaint before Deputy Commissioner on 28/1/2021, and immediately coming to know about the complaint, the instant FIR has been closed on 29/1/2021. The Deputy Commissioner, the report is also stated from the Deputy Commissioner, where it is also stated that no fraud was attempted to say Arindam. There they have approached the civil forum claiming their possessory right. So there is no criminal case against a petitioner, except there may be a civil dispute between the parties. Mr. Dev further submitted that, considering the nature of the case, the learned additional PP also moved an application for withdrawal of the case on 21/10/2022, but that same has been rejected by the learned trial court below, considering that some of the sections are. Where is the order you have?
My lord, page 28 and 29. Page 28.
That think that the 506 part 2 is a case which is not compoundable, as it is the penalty may as the penal provision is as the description of the term of conviction may extend to 7 years, and hence the notice, the government notification on dated 21/10/2022 does not cover present case. Thereafter, only the present petitioner had moved the application, praying for quashing of the entire criminal procedure initiated against him. Next, Mr. Gauhati submitted in that this civil suit may be pending before the court between the parties, but there is a criminal case already initiated against the present petition, and the case is fit for evidence on 9/2/2025, and hence he submitted that scanned copy of the TCR may be called for stage. Considering the submission made by so and so, that the TCR be scanned copy of the TCR be called from the internet trial court below, and also issue notice with the respondents through speed post and usual manner. However, no formal notice is required to be served on state respondent.
Lordship, in the interim, the matter may kindly
The copy, copy may be served to the state respondent. Further, considering the submission made by the the proceeding pending before court of, where it is pending?
Before the court of JMFC 1, Lordship, Kachar Silchar.
For the court of proceeding proceeding.
The Court of Judicial Magistrate First Class Kasar.
PRC, na?
PRC 533 of 22.
Proceeding in PRC case number 533 2022, pending before the Court of Learned GMFC Achar Silchipuri State till next date. List.
Much obliged, Lordship.
List of courts. Take one. Total case is down.
May I please, Your Lordship?
Yes.
Hello, here case diary received, but PM report, my lord, not yet received.
81 days in custody, Lordship.
CD available, my lord. There are statement of eyewitnesses and my lord, other witnesses available. There are.
If I, Your Lordship, if I have page number 12.
10103.
Yes, 103.
Page number 12, the FIR, Lordship. May I read the FIR, Lordship?
No, it's okay. You'll read the FIR, but what do you submit?
Because otherwise, my lord, statement of eyewitnesses and my lord, there are several witnesses, my lord, all implicated the present.
On the basis of that, if you're going to submit, we'll record.
Yes, my lord. Otherwise, your lordship, make any short date may be fixed. If otherwise, PM report, my lord, not yet received.
So in that case, if you return back the case diary, then
Yes.
I don't know.
Then also the
This is
CD is
also problematic.
CD is pending here since long, man.
Since long.
Yes.
Prisoner is not a sole accused, Lordship. There's 3 persons against FIR's Lordship. May I read the FIR, Lordship?
Then you're going to submit this on this?
Yes, on the basis of the materials, well, eyewitnesses statement.
May I read the FIR, Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 20/11/2025 তাৰিখে নিশা প্ৰায় 8:23 বজাত পদমগুৰি হাইস্কুলৰ খেলপথাৰৰ কাষত থকা আমগুৰি তিনিআলিৰ পৰা জুবিন ক্ষেত্ৰলৈ গাড়ীৰে যাবলৈ বুলি মোক খুৰাক লোহিত গগৈ গাড়ীৰ পাছৰ চিটত বহা অৱস্থাৰ পৰা শ্ৰী পলাশ গগৈয়ে খুৰাক টানি গাড়ীৰ বাহিৰলৈ গতিয়াই পেলাই দিয়ে। খুৰাই উঠিব বিচাৰোঁতে দিগন্তই গোৰ মাৰি পুনৰ বগৰাই পেলাই দিয়ে। পুনৰ খুৰাক পৰি থকা অৱস্থাত শৰীৰৰ বিভিন্ন অংশত গুৰিয়াই জখমী কৰি থকা অৱস্থাত সৰ্বেশ্বৰ গগৈয়ে খুৰাক গুপ্তাংশত কেইবাগোৰ মাৰি হত্যা কৰে। As per the affair, it is Lordship Professor Gogoi who has kicked in the private part, Lordship, and to my instruction is that, Lordship, the parent deceased person, Lordship, the villagers of the Odamguri, Lordship, they plan to visit Jubin Khetra of the Sonapur, Lordship, and accordingly, a bus was hired by the villagers, Lordship, and the deceased person, Lordship, Duncan, is that he get into a bus, Lordship, and get some havoc situation in the bus, Lordship.
You are Polach Gugoi.
I'm Polach Gugoi, Lordship.
Alias Ratul.
Alias Ratul, Lordship. So, concerning the length of detention, 81 days in custody, Lordship, and more for Lordship, the Pushman report, Lordship, 2 times called for, Lordship. They have not produced the Pushman report, Lordship. To my instruction, he fell down from the bus and got a head injury, Lordship, and he succumbed to his death, Lordship.
So, since when you were in custody? Since which date?
Lordship, over the very next day, Lordship, these 3 persons were arrested, Lordship, and they.
No. Since when you were in custody?
Lordship,
22.
Lordship, 20. No, Lordship. Next in the warning report, Lordship. Page number
22/11/25.
No, Lordship. 13, Lordship. Page number 13. 22/11, Lordship. 81 days I am in custody, Lordship.
Yes, whatever.
It was an accident, Lordship. Don't have intention to kill the person, Lordship.
Oh, yeah, but as far as it's not accident.
Yes,
No,
no,
Lordship.
All these witnesses, while eyewitnesses, directly implicated the present petitioner along with all the other accused persons. Only these accused persons were my lord, he once my lord assaulted the my lord deceased man.
Last 2 occasions they have failed to produce the postmortem report, Lordship.
He tried to board on a bus.
Yes, yes,
And he was in drunken condition.
yes,
Truly, on that context, there was an argument.
yes, argument. And thereafter, all these three accused persons were brutally
There
assaulted.
are some other persons also who also
yes.
forbid, stopped him not
Was
boarding.
there. All stated that only these accused persons were
No, made on the case of the 81 days,
What is this?
81 days in custody.
You have submitted for accurate.
Well, yes, all those eyewitnesses were implicated only the present accused.
What?
Only the present accused person and other two accused. All those eyewitnesses were only implicated.
Oh, yes, yes, implications.
Yes.
Just tell us, we have not received the PM report.
PM
That is one.
Last two occasions they have failed to produce the PM report. The third time the matter was listed before your lordship.
The requisition has already been sent, but not yet report.
Yes.
Artist the learned report, the learned an application. The receipt of submitted by Mr. Port. The PM report is not sent by the I, in spite of several intimation. Next point, submitted by Mr. Surya that the case for the on several occasions, the case was fixed for the postmortem report, but till that the postmortem report would not be provided by the I. It further submitted that the statement made it the FIR also it is seen that the deceased died only due to assault by one of the co-accused on his private parts. However, yes, he also admitted that there was some altercation and quarrel with the deceased, and but he has not assaulted the deceased in the manner or and he assaulted the deceased, and the deceased only died due to assault by one of the accused. Mr. Sutia further submitted that the accused petitioner is in custody since last 81 days, and hence considering his right to he will be released. However, he is ready and willing to extend his cooperation for the investigative case if he is provided with the privilege of it. Next, Mr. Waterford, United Christian PP submitted that though the PM report is not available, but from the statement made by the eyewitnesses and the materials available in the case diary, it is seen that the along with the other accused person present, accused person is also involved in the LS offense, and the deceased died only due to kicks and punches given by the present petitioner along with the other accused. Accordingly, he submitted that the prayer for bail may not be considered at this stage. Cannot be considered at this stage. Next, hearing the submission against diary. Therefore, it is seen that it is a case wherein quarrel took place between the deceased and the accused person along with some other persons while he was trying to board in a bus. There are materials, also there are some materials, incriminating materials also available against the present petition. However, the materials available in the case diary is seen that the probability of furnishing the charge sheet within 6-7 days is not possible at this stage, as the IO is still waiting for receiving the PM report as well as the report from FSL is still considering this aspect of the case without going detail into the merit of the case, only considering the length of detention I find that further custodial interrogation may not be required for the purpose of investigation. It is a case of which district?
Dhemaji Lordship.
CGM.
Allowed Lordship. Allowed Lordship. Obliged Lordship. Obliged.
It may not be possible. May not be possible. Huh? 3 may not be possible. There are many matters. We'll try, but may not be possible.
Idea number 12.
Yes, please, Your Lordship. My lord, regular bail application, my lord. FIR at page number 11, my lord.
Yes.
249 numbers of 500 fake domination has been recovered from the possession of the petition. This is the allegation. The petitioner is a e-rickshaw driver. My lord. He was hired by someone, my lord, and while traveling at the place of occurrence, that person requested me to stop there for a while, and thereafter they want to go. But in the meantime, police came and recover one bag from his e-rickshaw. That bag was belongs to that person, my lord, passenger. Petitioner, my lord, he has no knowledge about the bag, my lord. This is the fact of the case. And case has been registered, my lord, 180 and 181 BNS. As per allegation, as per FIR and forwarding report, 181 section is not applicable in this case. Therefore, he is 58 days to be in custody. 180 is mandatory period is 60 days and 181 is 90 days. 181 is not attacked in this case.
Why you think?
My lord, 181 kindly, if for a moment, my lord. Making or possessing instrument or material for forging or counterfeiting coins, government stamp, currency note, and bank or bank notes. 181.
Why are you saying he is not affected?
Because my lord, nothing has been recovered from his possession to which shows that he is preparing to make the fake currency or any instrument has been not recovered from his possession. Only notes has been recovered from his. That is my lord 180. And he is 58 days.
My lord, here we have received the case there, my lord. Here it was 249 numbers of 500 denomination, my lord. Into 5, my lord. 1 lakh something, my lord. It was recovered from his possession, my lord. Conscious possession, my lord. When he was carrying, my lord. And it was intercepted by the police and recovered from his possession, my lord. And here, my lord, it is not the case of, my lord, where 58 days or 60 days or 90 days offense, my lord. Here it is affect the economy of our country, my lord.
That's true.
It was the, my lord, offense which create about doubt about the economy of our country, my lord. My lord, here I have the strong objection for granting bail at this stage, my lord. Whether it is 58 days or 60 days, it is not the consideration, my lord. Here it was recovered from his possession, my lord. And investigation is going on, my lord, and it is also investigated whether he is, my lord, used the such type of, my lord, notes, my lord, fake Indian currency, my lord, for different purposes, or whether used or not, that is the different thing, my lord. Here, although he is in 59 days, my lord, here, I have the strong objection in this granting bill, my lord. It affects seriously in our economy, my lord. Here in the, my lord, ground of arrest, it was shown that, my lord, the fact and circumstances of the case clearly disclose that the accused is knowing and intentionally in possession of counterfeit currency notes, and the quantity recovered indicates that the same were not meant for innocent person, but for circulation, use as genuine. thereby attracting the indigents of under section 180 BNS. Further, his possession and movement with such a large quantity of fake Indian currency notes also prima facie indicates involvement in trafficking, handling of currency, counterfeit currency attracting under 181 BNS. That's why my submission is that my lordship may not consider his my lord,
As per provision, my lord.
and here is my lord FSL also not received. It was sent for FSL.
As per provision, my lord, handling, possessing, my lord, 181 not attacking. And for investigation, on the first day, my lord, the petitioner was arrested and he was sent to judicial custody. He has not taken into police custody, not prayer has been made. No any prayer has been made before the court, my lord, for police custody, further investigation.
Even if in the 60 days my lord offense, my lord, it is a serious threat to the economy, to our economy.
Everything is recovered, my lord. I will cooperate with the investigation. It is in paragraph number 5, my lord. How, my lord, from the petitioner was required. I have stated in paragraph number 5.
Is there any other note from the IO, or is there any other evidence that's apart from his position? He was also doing some other with the machineries and all for forging notes he prepared, or was the alloy involvement? This kind of things.
No, not here. But here is the my lord, only on the recovery. Huge amount of my lord, fake currency note.
It's, he is made a foot rickshaw, an e-rickshaw, and already person holding a bag came to hire his rickshaw. By the asked to stop the vehicle, and thereafter the police came and apprehended him, where from some fake currency notes the arrest will have been recovered. Submitted that the two cases registered section 1 and one of PNS. There is the section 181 is restricted against the present petitioner, as there is no ingredients clear by itself that he was using the machinery for preparation of the forged public fake currency. Fake currency. At best, the case by section 180 BNSS, wherein statutory period for 60 days. According submitted that is a permanent resident. It's not changed. That he will extend his cooperation for the investigation. If he is that then one with fake currency note with 500 denomination were recovered from possession of the present accused petition. And this kind of offenses also hampers the economy of our country. He accordingly raised objection and submitted that there is sufficient progress in the investigation. However, the FSL report is yet to be collected by the alia. He further submitted that irrespective of case whether attracts, irrespective of the fact whether the case attracts 180 or 181 BNs, but considering the nature of the offense, bail prayer may be received. Hearing this submission, the case record and the case diary is that it is the fact that there are negatives against wherein the fake currency notes were recovered from the direct position of presentation. However, released against the present accused petitioner to effect section 1 BNs at this stage. Though the investigation is still under considering on this aspect of the case, vis-a-vis the period of detention already, his bail price is there. Only মানে কলকাতা CGM
May I please, Your Lordship? So in this matter, last
Just
occasion,
you
Honorable
have
Court has
received here is that
City notice, ma'am.
not
50,
where
he-
it has to come?
And from
Morioni PS, Lord.
Orion.
Morioni.
Fine.
So 53 days, we are only behind the bar, Lordship.
Huh?
53 days, 2 days, Lordship.
Yes, Sharma, anything.
my lord, we'll produce the case there, my lord, within a short period, my lord. Small,
Is there 90 or 60 days of
Lordship, probably 60 days, except one section, Lordship.
no, it is
No,
90
my lord.
days.
1114 is there, 1113 is there, my lord.
Yes,
His life is there, my lord.
It is 90 days.
My lord.
Next week,
Yeah.
Lordship, any day, maybe.
Strict probability, I cannot say at this stage because there are many matters have been fixed. I don't know.
19th one. 19th.
19 to we have part third matter.
My-
We cannot.
19th month, yes.
17 and 19 are fixed.
My lord. Then 24th month.
And based on 20.
24th.
City not received. We listing it 20, hopefully.
My
by
lord,
20.
24th.
Lordship. Oblige.
My lord, I'm sorry, item 13. I also actually I appear for the complaint informant, but mention has been made. We have been not informed. Matter is in fixed. I come to learn 2, 3. In fact, he was arrested, and after some days he appears dishonorable court granted him interim bail, although he was arrested. He was in jail.
No,
That-
interim, he was, I have produced the record, he was an interim.
Yes, interim. That he should be released on bail by the court below. He was actually arrested. This honorable court called for the indemnity. He was released on bail.
Huh?
He was indemnity. He was released on bail. It is not an anticipatory bail, mail. It is a bail application.
Oh, yes, I know, bail application.
Yes, madam.
In bail application, interim was
Yeah,
granted.
granted. So, my lord, I appear for the informant. There, today's mention is I have not informed. So it is fixed on.
See, I'm repeatedly just saying
Totally.
this thing.
Let it be
Then
fixed on next week.
I just, whenever any enjoyment prayer is made, I generally ask,
Yes, my lord.
every court asks whether you have taken
I am waiting for very morning.
Is the
So let this matter fix on next day, my
yes,
lord.
we have taken consent and
Next week, my lord.
next day onwards, we cannot believe
My lord.
none of the advocates in that case.
They should at least inform me that I would have taken the time. Outside of the court also they can inform me.
Yes, obviously.
The next week it may fix, then they come in
I
force,
just
my lord.
forgot now, Mr. M. Hussain was there, I huh? W. Rahman, one W. Rahman came
I'm not
on
sure.
behalf of Mr. M. Hussain. Young advocate, he came, and he appeared on behalf of, I just then asked him, that have you taken consent? He said, yes, I have taken consent.
And I am
And then I perused the record because he's saying that it was interim was there.
yes.
I thought it is a bail application, why interim is there? Then I perused the record, but yes.
Well,
interim
I
was
have no objection if they taken zone. I have no objection at all. But should
there.
they?
If we fixed it now, so with 2-3, 3rd to 2nd of March.
Maybe the lordship. Here, lordship.
15 my lord, case diary received, my lord, case of dowry death, my lord.
Yes, lordship. Dowry
My
death
lord,
was
my lord,
where-
PM report is not conclusive regarding cause of death, my lord. Earlier, my lord, while arguing the case, learned petitioner, my lord, insisted regarding a dying declaration.
yes.
That's for which my lord, dying declaration was also called for along with CD. But while perusing the case diary, I have not found that any dying declaration was recorded, my lord. And here only regarding only one audio clip is, my lord, there is no notice available that an audio clip was recorded between the accused persons, whereby the accused persons before the death of the, my lord, deceased, accused person, my lord, threatened, he talked with someone to kill the, my lord, deceased, my lord. That is before the, my lord, my lord, death took place. Otherwise, there I have not found that regarding any recording of the, my lord, dying declaration. I will have to get instruction because victim, my lord, here my lord, consumed administered, my lord, poison on 21/12/25. Thereafter, my lord, initially he shifted to Bizni Bergaon Hospital. Thereafter, my lord, Borpeta Medical College. Thereafter, Swagat Hospital, Bongaigaon. And ultimately, she expired on 27/12/25 at 3:30 p.m. So now from the CD, nowhere I have found that any dying declaration was recorded.
That may be there.
Because at that point of time, my lord, he insisted to call for the dying declaration, for which dishonorable court has called for the CD along with dying declaration. But here CD
their
is
lordship.
me-
Or with their
CD
showing
is-
their lordship.
Dying declaration, I don't know.
no
whether
mention.
there is
I have not
No,
found-
no, no. Whether it may be not maybe in a written form, where there is any oral dying declaration.
No, my lord, I have not found there is any such.
Someone
note.
before someone she stated.
I have not.
Minister.
It may not be there, but you may take a lot of instruction from them, lordship. Others, however, we know lordship, the dying declaration is their lordship. Police recorded their statement, lordship.
Police recorded.
Yes, lordship. Recording is yes, lordship.
My lord, regarding.
But some of police policy has misguided, lordship.
Well, I have not. I have regarding how he can say that, my lord.
A hospital, she was in the hospital.
Then I will
always with her. While she was in the hospital, lordship, we are always there, lordship.
You were there with.
Yes, lordship. We treated her, lordship. And lordship,
And during, my lord, here one advertisement is also there in the petition, my lord. According to them, my lord, they record at the time of recording their dying declaration, the victim, my lord, named someone other as the accused, my lord.
Yes.
But how that can be, my lord, believable, my lord?
that's all, lordship. We also lost an
Otherwise, my
FIR.
lord, I can only go through the record, my lord. Whatever is there in the CD, only that I can point out. This is their submission.
He may take
As per who recorded this statement, dying declaration?
lordship.
Doctor.
No,
Who recorded?
police lordship. We also lost an
recorded?
lordship. We also lost an FIR, lordship.
How police can record?
No, police lordship visited their lordship because we also lost FIR, lordship.
Police, how police can record?
That lordship, police owed the lordship. Perhaps he recorded on lordship.
Otherwise, my lord, how that can be believable, my lord?
Police cannot record.
And lordship, otherwise, lordship, we also lost some other person also recorded her statement, lordship, in video, in audiography, lordship. Then, lordship, we come to know that neighboring lady, lordship, she insisted her to consume the poison grass killer medicine, lordship. Because, lordship, some villagers, lordship, they blame the lady that she has a relationship with her father-in-law, lordship. That's all, lordship, many people blamed her and insisted her that you may consume poison anything, lordship.
Those are
And
their,
in this way, lordship,
those are their submissions, but
yes,
the
lordship.
materials available on record. So there are sufficient.
In this record, we also lost an FIR, lordship.
Statement of the witnesses available in the CD regarding demand of dowry, regarding
one thing, if he is insisting on that,
Yes.
because on the last
Yes.
occasion also most probably as he insisted, so dying declaration was called for,
yes.
but that is not available. And you have not received the PM also.
PM report received, but that is not conclusive, my lord. Regarding
That is
cause.
not conclusive. Now this in that case, we can go by the statement of the
Yeah,
witnesses also, but
yeah.
whatever. Now, he is insisting that he
Yeah.
named another lady.
Yeah.
So you just can
your
be
lordship-
written, or you can take instructions.
I will get instruction, my lord. Otherwise, I can also send back the study for updation, my lord. And I will also get the instruction over phone, my lord. Regarding
Sending back will be.
Otherwise, I will try to.
How long he is in custody now?
Lordship, now as on today, Lordship,
From-
46 days, Lordship.
From 29/12.
And otherwise, Lordship, I have one another submission, Lordship. Here the husband and father-in-law is the petitioner here, Lordship. Husband and father-in-law is the petitioner here, Lordship. Now, Lordship, in the house, Lordship, nobody is there, Lordship. Only one school-going Lordship, student, Lordship, is there, Lordship, and his examination is going on, Lordship. His medical examination is going on, Lordship. I have the document, Lordship.
No, whatever.
Lordship, on this ground, Lordship, only father may be released on bail, Lordship, either interim or renewable, Lordship.
There are materials.
Already one day examination gone, Lordship, and nobody is at home, Lordship.
They will appear themselves, or what to do?
Lordship, at least.
Mr. S. Hockland, Mr. Bigor. It is submitted by Mr. God for that the CD receipt, but the PM report is not the conclusive one, and that apart, the CD reveals no, there is no dying declaration along with the in the CD. However, it is submitted by Mr. Hawk that the deceased gave her dying declaration, and in presence of some persons and police, and he's saying that the dying declaration must be available in the case record. His diary. But as the same is not available in the case diary, the learned additional people hereby asked to take necessary instructions from the IO concerned as to whether any dying declaration was recorded for date of the deceased in the hospital. Now, retaining the case diary.
Yes, my lord. I can also, my lord, that may not be recorded. I will talk with the IO and do the needful, my lord. If my lord, he wants to take the CD and again, my lord, he can return back before the.
No, but whether we'll pass the order of detainment here?
No, my lord, no, your lordship may not record
some order.
Yes.
Your
lordship may fix the matter. Your lordship may simply fix the matter on a particular date, before that date. My lord, I will.
Okay, then fixed it.
Lordship, connected matter is fixed on 18, Lordship. Another matter is fixed on 18, Lordship. Another matter is there, Lordship, that is fixed on 18, Lordship.
Case number.
What is the case number?
Number, Lordship, BA, Lordship, 365.
BA 365.
Yes, my lord, this matter might take along.
18 corridor along with BA 365. Okay,
Lordship,
well,
Lordship.
Eight people.
yes.
Well, it's a regular bail application. My lord, accused was arrested on 22/12/2025. It's been 52nd day today, my lord. And FIR is based on the allegation of criminal conspiracy, cheating, criminal breach of trust, and attracted the section 61(2), 318(4), and 316(2). Lord, all these sections are the punishment is up to 7 years. So, my lord, 60 days period is going to be over within 7-8 days. My lord, the FIR, your lordship will find at page 11. Now, may I read this FIR? My lord? It's been filed before the officer in charge, Doboka Police Station. Informant's name is Sahit Bosumatari, and the name of the accused is Sukur Singh Terang. It's from Dokmoka Police Station, Karbi Anglong. Sir, I have the honor to state before you that Sukur Singh Terang is known to me for last 1.5 months. After being acquainted with him, he told me that he would provide me a job at Forest Department upon payment of rupees 10 lakhs to him. Since I am a petty businessman and in need of a government service for my better future, I arranged rupees 10 lakhs and called him over telephone on 10/12/2025, upon which he told me to come to the Dokmoka market along with the said money. Accordingly, when I went there at about 2:30 p.m. and provided him the said amount of money, he told me that he would provide me the appointment letter at his residence. And as such, while going to his residence from Dokmoka through Hauraghat, 3-4 persons came out from one Alto K10 car, which was parked on the side of the road, and instructed us to stop. And when he stopped his bike, the said person searched us, and when they got the bag containing the money of rupees 10 lakhs, they took him along with the money in the said car, and one of them fled away with his bike. Though I, along with my friend Sri Sagar Kaklari, searched for the said person, his bike but we could not find them. I have sufficient doubt that all these have been planned by Sukur Singh Terang. Accordingly, I pray before your honor to investigate in the matter and take necessary action. Lord, allegations are there in the FIR, but I'm not going into the merit of the case. My only thing is that both are businessmen. They have some business rivalry between them, and so certain monetary transactions was related to both this particular petitioner with the accused person, with the informant. So that's how there is a previous rivalry between these two persons. So out of that, this FIR has been filed. Well, my only prayer is that further custodial detention, considering 52 days detention, Miller, may not be required in this case.
Is there any recovery also?
No, only
1 lakh rupees probably police recovered from his residence, but that amount, according to him, that amount is his own money kept for the purpose of his business.
Yes.
My lord, after arresting the present accused, my lord, on being leaded by him, that 1 lakh rupees recovered, my lord, and thereafter, my lord, total 10 lakhs, my lord, the informant has given to the accused person, my lord. Now 9 lakhs yet to be recovered, and one other accused person, Amor Pro, my lord, who was not yet arrested, my lord. Police suspected that only after his arrest that can be, my lord, recovered. One, and regarding, my lord, one other, my lord, one friend of the informant who was present at that point of time when the, my lord, accused persons took away that amount of rupees 10 lakhs, my lord, his statement is available. He clearly, my lord, stated how these persons, my lord, in a planned manner, after that, on the pretext of providing job in forest department, took away an amount of rupees 10 lakhs, and immediately after receipt of that amount, he along with his friend, my lord, paid away in that Alto K10 car. My lord, that friend, regarding my friend already mentioned about one Sagar Kaklari, his statement is also eyewitnesses is available in the city. So there are materials against the accused person, and total 9 lakhs yet to be recovered.
Just tell us, otherwise it is a case of 60 days of.
Yes, that is the difference.
Absolutely.
No, it hard to try and talk with. Legal and additional appearing on behalf of state application it is submitted by Mr. Chaudhary to the petitioner and is such as a legend here. However, it is the fact that there was some monetary transaction between the present petitioner and the accused as their business part, as they have business, and prior to the incident there was some transaction of money for some business rivalry only. The present FIR has been lost with some false and concocted suspicions. In custody since 52 days, and hence considering his detention is priority. He is being a permanent resident. There is no chance that he will cooperate the eye further investigation. Mr. Watercourt, with an additional people submitted that there is sufficient in the case diary. And apart from that, rupees 1 lakh has already been recovered from the possession of the accused person. But the remaining 9 lakhs is yet to be recovered. Post, as per note of the IO, the remaining portion of money may be recovered only on arrest of one of the co-accused. However, the police is in charge of the co-accused. He could not be apprehended. Next one. In this section, we said in favor of the diary, it is seen that there are some matters against the present petition, but from the stage of investigation, it is seen that it may not be possible for the investigating officer to submit the charge sheet within the statutory period. Without going detail into the other merit of the case, only considering the length of the petition, I find that the IO was sufficient opportunity to interrogate him, giving him in custody as further means Kabian, CGM.
My lord has considered.
Yes.
My lord, I am applied.
Iman?
May I please, Your Lordship? Let's say before going to FIR, Your Lordship, what happened, Your Lordship? I am the petitioner, Your Lordship. I am a control shop of the government, Your Lordship.
You are the?
I am a control shop holder of the government shop. It is a government shop. During the first week,
Is a fair price shop?
fair price shop, yes, from
Oh,
the
you have a
government.
fair price shop.
Yeah, fair price shop. Control, it is a control shop. Controls, in Assam is control dukan. This is like this.
Controller
You know what happened in the first week of the every month, your Lordship, I am busy for to disburse the government commodities to the other beneficiaries, which are selected by government. Then after completing this proceedings, Your Lordship, on 10/1/2026, Your Lordship, I came to Biswanath Saharli supply inspector to submit that report. When I returned, Your Lordship, at Balipukhuri place, National Highway 15, Your Lordship, some police checking is going on. I dropped from the another vehicles, passenger vehicles, and I waiting another vehicle. This is one type of four-wheelers like Creta. I waiting in nearby this vehicle, Your Lordship. When checking is going on, Lordship, from this Creta vehicle, some fake gold is recovered. Then, Your Lordship, 2 persons in the vehicle, Your Lordship, Creta vehicle, then police pick up me along with these 2 persons. And when go to the Jinjia police station, and I know, Your Lordship, at the Jinjia police station, that I was arrested in connection with some fake gold. But I have no knowledge about this, and I have never seen these 2 another persons, Your Lordship, anywhere and any before time, Your Lordship. And I am no related with this vehicle also. From the dead vehicles, fake gold is recovered, Your Lordship. So, and I am fairly said about this fact, but the police next day on 11th, Your Lordship, I was forwarded, Your Lordship. I have no any connection with this vehicle, Your Lordship. I am neither in the passengers in this case. I am nor the drivers and nor is any other person, Your Lordship. I am already behind the bar, Your Lordship, 30 days, Your Lordship, without any connection with this fake gold, Your Lordship. And there is no any person, whether it is the commission is committed or not, I have also no knowledge, Your Lordship. I have no any relation with the vehicle also, owner also, driver also, and other passengers also, other accused also, Your Lordship. And Your Lordship, what happened? There is a section is coming, Your Lordship, criminal breach of trust and sitting. Who I am sitting by me, Your Lordship. I have no any relation with this vehicle, so how can it is coming criminal breach of trust here? So let's say my humble submission is that I am already behind the barrier 30 days without any my wrong and without any my offense, Your Lordship. Kindly consider me, Your Lordship. This is my humble submission before your honor.
Yes.
My lord, petitioner was arrested on 11/1/26. My lord, total 0.228 kg of fake gold recovered from the present petitioner along with two others, my lord, from that Hyundai Creta vehicle, my lord. Only on the ground.
Hyundai Creta vehicle your honor, it is.
Well, at that point of time, police apprehended those three accused persons along with the present accused, my lord. And thereafter, my lord, from the dicky of that vehicle, Hyundai Creta, that 0.228 kg of, my lord, fake gold was recovered. So he was present along with the other two accused persons. Only considering the length of the
Is there any other?
my lord, otherwise, yes, on that day only because, my lord, he was present by along with it is not that he was not present along with the
I am present, your
other two
lordship,
accused
but
persons.
I am
He
coming
was
from another
while
place.
police my lord, apprehended that, my lord, vehicle. He was present along with the other two accused persons, and from the three accused persons, those fake golds were recovered. Otherwise, investigation.
The recovered the dicky of the vehicle.
Person who are also the co-accused.
Yes, one of
Is there any statement that he was also witness because those as per
no, my lord, the other co-accused has not stated any my lord, what was the
And you also co-accused one of the Islam and another vehicle also already released by the session judge business.
Islam and one Deposit Sagar, they named accused, my lord, from his statement, my lord, he has stated the present petitioner, he along with Babul Islam and Deposit Sagar, my lord, গাড়ীখনৰ সৈতে মোৰ লগৰীয়া ৰোডত থকা ৱাটাৰ ছাপ্লাই ষ্টেডিয়ামৰ সন্মুখেদি সোমাই যোৱা এটা গাঁৱলীয়া বাটত বাবুল ইছলামে চলাই লৈ অহা চ' while Babul Islam was driving the vehicle, he was there in the Hyundai. It is not that only because he was standing, my lord, there while the Hyundai Creta vehicle, but while Babul Islam was driving the vehicle, he was in fact inside the vehicle. The present petitioner.
It is whether it is I have no knowledge, but what happened is the Babul Islam already released by the session judge Biswanath Chayali, and the vehicle also already given custody.
But otherwise, there is no such materials, my lord, against directly against the co-accused also, my lord, has not stated. Anyway, my lord, only considering only on the length of detention. Otherwise, investigation is still going on. Those things may not be required.
Additional PPA. The second line of that be connected with the other. He the co-accused person or he is anyway related with the vehicle where the alleged recovery of vehicle was the alleged recovery of vehicle was that. The further submitted on the day of incident after his fair price saw he was coming to Sanachariali while he was waiting near a Creta vehicle. Police came and apprehended him along with two other co-accused. He never even saw any vehicle, nor he is associated with the other co-accused. However, he is in custody since custody is 30 days, hence considering his length, his prayer may be next Mr. Court. Done it. Additional BP submitted in this regard that there are matters case diary against the present petitioner, and the fake code was recovered from the person of the petitioner along with two other co-accused persons. And the investigation is still hence it is and submitted that his bail prayer may not be considered at this stage. With his diary and considering the metrics of his diary and the other statement made by the co-accused, I find that further custodial interrogation may not be required for the purpose. India police station means under which district?
CGM
Yes.
Biswanath.
Huh?
CGM Biswanath.
India under Biswanath. District. Okay, you're done. Bail is granted.
Obliged.
My lord, CD not received. Petitioner is an interim. My
To reminder, estimate accordingly on 2nd of March 2025, 26, and interim be extended till next.
Yes.
May I please?
19 you have received case diary.
This matter also, my lord, listed on for many occasions, man, for CD, my lord. Case diary has not been produced, man.
19 CD received. My
19.
CD received, my lord. Well, petitioner is in interim, my lord, but a detailed note of the IO, my lord, dated 10 to 26 after obtaining interim, my lord. She has not yet appeared before the IO for recording her statement. And for which IO has prayed for cancelling the interim, my lord. This is the
My lord, in this regard, my lord, I have filed an affidavit, my lord. Kindly bear with me. As per the affidavit, my lord, the accused appeared, my lord, petitioner.
that report is of 10 to 26.
Where is the affidavit in page number?
Yes, my lord.
Affidavit.
Affidavit.
Yes, I have received. Yes,
I've
yes.
filed an affidavit.
By the
Appeared, but
affidavit, as per affidavit, when you appear?
appeared, my lord, but her statement was not recorded, my lord.
Appear
Appear-
when you have appeared?
Yes. My lord, para 4, my lord. Kindly bear with, my lord.
14/7.
Yes, my lord. At 4 p.m., my lord. And also original of the certified copy handed over, my lord. Thereafter, he was not, my lord. All, my lord. He was. And the entire allegation, my lord, against one Dharmeshwar Roy, my lord, and she is the wife, my lord, of Dharmeshwar Roy. And Dharmeshwar Roy, my lord, already granted bail, my lord, interim bail, my lord, anticipatory bail, my lord. Page 22, Annexure 5, my lord, of my petition, my lord.
Your notice when?
Entire allegation against Dharmeshwar Roy.
Your the IO, as per IO till 10 to she is not appeared.
10 to
Till
26, my lord.
she has not appeared.
Not. That is the report of the IO dated 10 to 26.
And whether the original this certified copy is available here?
CD, my lord.
A certified copy of the bail order, interim bail order.
That my I will have to again check, but I have not.
No, he is saying that it has already been
Yes, my
handed
lord.
over.
I have also stated, my lord.
Your lordship may pick some other day. I will have to get the instruction.
My
Otherwise,
lord, entire
present-
allegation, my lord, against my lord
Well,
Dharmeshwar Roy.
again,
He is the husband of the present petitioner, my lord. Kindly peruse page 22 of my petition, my lord.
There are total 14-15 cases pending against the husband of the present.
That is another matter, my lord. The thing is this, my lord,
In
against
some of the cases, my lord, the present petitioner also involved along with my lord, her husband.
That is another matter, but
And in all those cases on medical ground, my lord, he was, my lord, interim bail was granted in some cases, and my lord, he was directed to surrender before the trial court on a particular date. But thereafter also he has not surrendered by way of filing, my lord, application. My lord, at all times he has filed extending application. In some of the cases, those were granted, and my lord, some cases are still pending.
no, all are disposed of, my lord. No updated CA, my lord. Thing is that kindly page the FIR page 15, my lord,
No, I'm not.
of my petition.
Heard Mr. Given number 90. Heard Mr. T. Hussain regarding council facilitation. Also heard Mr. Board regarding everyone said it is submitted by Mr. Bott that the CDC, but there is no the statement of the
My lord, another
application.
prayer I have, my lord, in this case. As per APD fit, my lord, I specifically mention the date and time, my lord. CCTV footage.
To think again calling for this.
If there is any
This
doubt,
kind of
my lord,
preference we are not going to take.
my lord, if
Stop,
there is
stop.
any doubt, my lord, then CCTV footage may be called for.
Statement of the present petitioner availability case record. Case record. And ITT IO has also placed a note dated 10/2026. Submitted that till date she has not appeared before the IO and her statement could not be recorded. Accordingly, the IO prayed for cancellation of her interim bail. Mr. Hussain did done it that as per her as per the instruction of petitioner. She appeared before the IO on 14/7/2025 at 4 p.m. for recording her statement, and the certified copy of the interim order was also handed over to the this person. Her statement was not recorded on that day, asking her to come on any other day. Accordingly, Mr. Sen also submitted that the petitioner also prayed for call for the CCTV footage of from 3 p.m. to 5 p.m. dated 14/7. In context, in view of this, the additional duty is hereby directed to take instruction as to whether she appeared before the IO or as to whether appeared before the IO or her statement was not recorded as claimed by the petitioner. Now, like take necessary instruction in this regard as to whether the petitioner appeared before the investigating officer after obtaining the order of interim.
Lord, if
CDB returned according to directing IO to furnish the copy of the statement of the victim if already recorded, and if the same is not yet recorded, the petitioner is hereby directed to appear before the IO within 7 days of the date of court. Record her statement. That will be fixed on 5/3/2025. Interim be extended till next day. To go and appear before the
yes, my lord, deeply aware.
Okay.
Huh? Can copy means it is a charge sheeted case.
Lordship.
You are for the informant. And we have received this
TCR, Lordship. I have gone through the TCR. The victim have implicated the accused person.
And this is the photographs of the victim.
Lordship.
Both and fracture, head injury, notification.
Yes, I have seen. None appears on call for the petitioner. Or Mr. R. Ali did not appearing for the information, Ms. M. Begum, A. Begum for the learned edition. Scan copy of the DCL has already been received. However, due to absence of the present the counsel for the petitioner, the matter let the matter be listed shortly. 16 to we are giving short. Lodged into interim be extended to the list.
Okay.
Please, your lordship.
As we have received here.
Is there not received, lordship?
Interim is there, lordship.
Huh?
Interim is there. Interim is
Interim was there. She did not receive. Issue reminder. Let the matter be accordingly listed. When it can be listed?
Interim আছে।
Deeply obliged.
Interim be continued.
23 also case they not received, lordship. They are on interim.
She did not receive. Issue reminder. 10-3 will do. Step is not 10-3.
10.
Interim be continued till listed.
Lordship, one IA has been filed with regards to the bail, anticipatory bail application to remove the name of the petitioner number 2. Before granting the bail by this honorable court, he has been arrested. So we have filed an IA to remove the name.
I is not before us today. That I is not here today.
Only AB is there. It will have to be listed in the list.
One IA, what is your number of the IA is 4. 4, is it 4?
Yes.
4, lordship.
Oh, it has already been disposed of. Your prayer that the name of so and so, it already been disposed of. So next time when you make submission, just remind us that you are not pressing the petition for the other act.
May please, your lordship.
Just a second here.
No,
you
the
have received here.
anticipatory bail application in your certificate.
TCR, lordship. TCR is there.
TCR
Report
is
has come, my lord.
okay.
I am only that, my lord, this is a case, my lord, where a boy and a my lord girl, they were in love. They were measured. My lord, that subsequently a case has been lost, my lord, regarding kidnapping, my lord. And my lord, the main accused, the boy, my lord, he was arrested. And he was released, my lord, only 2 days back by the trial court. These 3 petitioners, my lord, they are the relative of the my lord boy. So they will face the trial, my lord. Only problem is that, my lord, kidnapping offense is sessions triable. So, my lord, if I appear before the magistrate, my lord, there is likelihood, my lord, I may not be released on bail.
Yes.
Lordship, in 164, and that is in the 183 and in 180, she have implicated these 3 ways that they have came and kidnapped her, lordship. In 164, I have flagged it, lordship, in this year. In 160, 183 of BNS and 161.
Only thing, my lord, as the charge sheet has been submitted, my lord, will face the trial, my lord, whether, my lord, custodial detention at this stage will be necessary or not.
But what prevented you from appearing before the IO during the investigation? You have not appeared before the IO.
No, my lord, we are not on interim, my lord.
Oh, no. Interim, you are not interim, but
Right.
you could not be apprehended or arrested by police during
We
the
were there,
investigation.
my lord, but as we have applied for the, my lord, the anticipatory bail. So, my lord, as if we were absconding, my lord.
Because there is an allegation in 165 gang rape.
So what is the state
Gang
of the
rape, my
case?
lord,
at
may,
present?
may I just read the, my lord, affair, my lord?
Is there any warrant issued against you or a summons is only issued?
My lord, summons have been issued.
Summons.
From the affair, there should not be any gang rape, my lord.
In 164, she has 164 that she was tied and then committed bad acts with her by 3-4 persons.
All of them.
3-4 lordship. It is in her 164 and 161. That is 183 and 180 lord. I have liked it.
3-4 months.
It will admit to say that we did. That I have, no, she have before also left with her one. Who's brought her because she was the boy was of minor age. But at last we have it. And the thing is that lordship, she admitted that she was in love with Hafizul, but when they took away and when she raised hue and cry, then her uncle came out. Then they have assault him and his head also he have injured, he was grievously injured lordship and her aunt was also injured. Then they have taken her and tied her. It is only a so 164 and 161 I am submitting.
Yes, I have seen.
Whether, my lord, any, my lord, medical report, there was a, my lord, allegation of report of, my lord, gang rape. Because, my lord, affair, nothing is there, my lord.
She's
Both
major.
a
lordship.
boy and, my lord,
Otherwise,
girl.
she's major.
Huh?
She's
Ah,
major.
both of, my lord, about the age of 1920, my lord, boy and girl. They had love relation. They eloped, my lord. And affair allegation, my lord, that all these people came to, my lord, solemnize the marriage to their house, my lord. Is it possible, my lord? Somebody will come and solemnize marriage in the girl's house, my lord. We'll face the trial, my lord. That is my only prayer before lordship.
Your lordship, it is Babul Hussain lordship. Groom come to the girl house only.
Babul Hussain.
Lordship.
Babul is it about 42 years, my lord.
Accused is Hafizul. Main accused.
He is the boy.
The affair and she earlier also went away, but she was brought back by police. Lord. It is in the record. Lord.
Abijul.
Now, as they were not of adult age lordship, then they came and kidnapped her according to the record.
Hard Mr. PM Chaudhary, Dilanet Council. Also, so Ms. A. Begum, Dilanet. Additional PFP appearing. It's an application. And copy of the case diary has already been received. This is submitted by Mr. Chaudhary, Dilanet Council petition that these three accused persons are innocent and they are not connected with the arrest. It is a fact that one Hafizul has love affairs with the victim and the victim eloped with him, but in the said kidnapping, the present accused petitioner had no role. However, they applied for their anticipatory bail, which was rejected. by which court he had rejected?
Nagaon minus now. Session judge Nagaon first.
Judge of the- and hence the case is session trial. The petitioner could not appear before the court during the investigation. However, all the accused petitioners are now ready and willing to appear before the learned trial court below, contest the case, if they are provided with the privilege of pre-arrest bail. Next, MS Bekul, the learned additional PP submitted in his that these three accused petitioners are also involved in the alleged kidnapping, and as per statement made by the victim under section 180 of the 183 BNSS, she implicated these two petitioners also, wherein not only she was being kidnapped, but she was raped by all three accused petitioners, including the main accused. Ms. Bacon accordingly submitted that it may not be a case for extending privilege of pre-arrest bail to different petitioners. Next, hearing is sufficient, made by learning consequences is seen that the name of the present accused petitioner were also there is already victim also implicated the present accused petitioners. And in the same time, it is also seen that rejection of their anticipatory bail prayer. They have not surrendered before the court, before the IB, and did not cooperate in the investigation. Thus, it is seen that in spite of having knowledge about the pendency of this case, they did not cooperate in the investigation, and for which they were shown as an absconder. They were shown as an absconder in the charge sheet. However, considering all the circumstances of this case, these three petitioners are provided with some interim protection for 15 days from the date of order, and within 15 days, they will apply for their regular bail for the learned trial court below with an appropriate application for bail, which may be considered in accordance with. Till 15 days from the date of order, no corrosive action shall be taken against it. They were provided with some interim protection for 15 days. Interim protection for 15 days.
Congratulations.
Decisive reasoning.
Yeah.
Huh? Lordship, CD is not available, Lordship, due to some requests have been made by the IO Lordship to give another date.
Interim candidate, Lordship, on 4/2/26.
You are on interim.
Yes, Lordship.
Sit not intimated by the IO that due to some that CD could not be intimated by the IO that CD could not be produced due to some reasons. Why it cannot be?
Lordship, this is therefore I am unable to submit the required CD in this regard. Request your honor to kindly verify the mentioned case number and issue a necessary correction for further needful action.
Oh, that is your
Some wrong case number has been.
Oh. So what is the case number in fact?
Case number 4320.
PS Alu Patichar. Alu Patichar, PS.
Non-FIR case.
For report form whether case is filed or not, FIR filed or not. Lordship, then I will get it, Lordship.
Not yet filed, FIR. FIR is not yet filed.
Not yet filed. And date maybe I'll.
I don't know. In one hand, you are saying that no FIR, and on fifth para, it is saying that due to political level and only to harass the petitioners. On 18/11/2025, the informant had lodged an FIR before officer in charge Alupati Chowk police station. So whether case is registered or not, I don't. What do you want to submit now?
What is your submission? There is any case or not? You have written it.
No case.
Huh? No case.
No FIR. No.
You have inquired.
So why you have stated in your para 5 then that FIR has lost? Iba ko sa dito po na ito.
Informant laws and FIR before Alupati PS in para 5 on 18/11.
Actually, what is your stand? Your case has been registered. Your FIR is lost or not lost?
Not lost.
Then why are you saying in para 5 it is lost? Huh?
Doctor, my senior is not there today. Huh? Doctor, I am not aware about this. Doctor, my senior is not present today.
What order will pass? He is saying that this kind of is not there. Now there's in an Alupati PS or case number 143.
Alupati PS case number 4326. Report.
Now they are saying that they have not closed any FIR.
Let the matter come, no, only the adjournment order may be made, Lordship, because he is also not aware, Lordship. And we will get all the.
So where from you got the number, Alupati or PS case number?
That one, Lordship, in the report of the IO, Lordship.
No, in the order also, it is reflected.
Fifth.
No, not fifth. In our order, this court order is also there reflecting the case number Alupati Chowk.
Lordship, it is through the report, Lordship. Huh? Herbal instruction police or para Alupati police station, case number 43/26. It is yet it is say.
No, I'm not on that. In the order passed by this court, there is also mention about.
Mention about instruction.
Yes.
But on what basis they are on interim? I don't know.
Because when of the report of the IO,
He dropped the order to connect. The order to connect. The court had passed the order. From where from the court had passed the order?
Herbal instruction.
Because here there it is that one report was there. Alupati PS case, short case.
A report dated 30.
So he is not in a position to say anything now.
Date may be fixed. Better
Let
date may be fixed.
considering this submission made by Matter is adjourned with the direction to the planet petitioner to take necessary steps as to whether any case has been registered against the president. Is the matter already on 2nd of March or 3rd of March? 6th of March, going to interim be continued till next year. We are still providing you the interim. We don't know whether case is there or
27.
Made page your lordship. Here my case study was called for, my lord.
Madam, here we have received the information that charge sheet submitted, madam.
Sati submitted, my lord. I mean, allegation is there, my lord. I, my lord, sold a fake, my lord, bull boat, my lord. Lordship may direct me to apply for regular bail, my lord, before the concerned court. Some protection may be given till then, my lord. My lord, some protection, my lord.
hard matter SM to the P return hard distribution. It is submitted by Mr. Sharma that case has already been charged by CS
I charge sheet number 03/26 dated 6/1/26.
In view of this, a present petition is hereby directed to approach a learned trial court below an appropriate application for it which may be considered in accordance with the above observation. Sorry, Mr. Abdullah, we cannot pass any order at this stage. So, did you appear first before the court?
Can it be like this, my lord? Will appear, my lord, for regular bail after receiving of the till receipt of the summons, my lord. No protection, my lord. No protection. I don't want, my lord. After receiving of the summons, the petitioner will appear, my lord. Can that be passed? Oblige, your lord.
This case, my lord, the informant as well as the accused person.
You're appearing, no? Your name is not.
My name is not shown today, unfortunately.
Ah, yes.
Right. Lordship, in this case, Lordship, the informant and the accused person are good friends, and they are belong to the same village, and both of them are married. But husband of the informant doubted that there is something beyond the good friendship. Accordingly, he insisted to discontinue the relation, and finally he insisted the informant to lodge FIR against it. Page number 12 is the vernacular one. This is original. This FIR does not disclose any commission of cognizable offense. Lordship, I may be allowed to read it in vernacular language. সম্মানপূৰ্বক বিনীত নিবেদন এই যে আজিৰ পৰা এবছৰ ছমাহমান আগতে এদিনাখন মই বেংকৰ কামৰ বাবে মাটিয়া ইউকো বেংক অভিমুখে গৈ আছিলোঁ। সেই সময়ত 1 নং পদকীয়াই মোক মটৰচাইকেলেৰে আগুৱাই দিয়াৰ প্ৰস্তাৱ দিয়াত মই সৰল বিহাৰত 1 নং পদকীয়াৰ মটৰচাইকেলত উঠোঁ। কিন্তু 1 নং পদকীয়াই মোক মাটিয়া ইউকো বেংকলৈ লৈ যোৱাৰ পৰিৱৰ্তে মোক জোৰপূৰ্বকভাৱে দুধনৈ লৈ যায় আৰু মোৰ শালীনতা হানি কৰাৰ লগতে বেয়া ইংগিত দিয়ে। মই এই কথা পৰিয়ালৰ লোকক জনালে 1 নং পদকীয়াই হত্যা কৰিব বুলি ভাবুকি প্ৰদান কৰে। প্ৰাণৰ ভয়ত মই উক্ত ঘটনা মানুহক নজনাও। This paragraph indicates that when the accused person offered her to give a lift, she accepted, and both of them are known to each other. And there is also, and this is also falsify the sudden criminal intention because voluntarily she has accepted. And the second part, 1 নং পদকীয়াই মাজে মাজে মোক কুপ্ৰস্তাৱ দি থাকে আৰু মানসিকভাৱে হাৰাশাস্তি কৰি থাকে। যোৱা 29/11/2025 তাৰিখত ৰাতি অনুমান 10টা বজাত মই যেতিয়া বাহিৰত প্ৰস্ৰাৱ কৰিবলৈ ওলাও তেতিয়া পদকীয়াদ্বয়ে পূৰ্ব পৰিকল্পিতভাৱে মোৰ মুখত সোপা মাৰি ধৰি বলপূৰ্বকভাৱে 1 নং পদকীয়াৰ ঘৰলৈ লৈ যায় আৰু 1 নং পদকীয়াৰ ঘৰত আবদ্ধ কৰি মোক মোৰ ইচ্ছাৰ বিৰুদ্ধে দৰ্শন কৰে। ফলত মই অজ্ঞান হওঁ। পিছদিনা অৰ্থাৎ 31/1/2025 তাৰিখত মই সচেতন হৈ চিঞৰ কৰাৰ ফলত 1 নং পদকীয়াৰ ঘৰৰ মানুহে আগবাঢ়ি আহি মোক মাৰপিট কৰে। দিছ ইজ ইম্পৰ্টেণ্ট। পিছত চিঞৰ বাখৰ শুনি চুবুৰীয়া মানুহ আহি মোক উদ্ধাৰ কৰে। Lordship, I am a married man,
and I am living in a family where my parents are also with me. My children, my wives are also living with me. So allegation is that I have kidnapped her and kept her in my room, and in presence of my other family member, I committed rape, and my other family members also beaten her and assisted me to commit the crime. This is the story. So this story itself indicates that there is something wrong. And Lordship, importantly, assuming that it is correct, then why the FIR is filed only against me? Why not my family members? Because they have assisted to commit the crime. Surprisingly, their name is not there. And the story which is narrated in the FIR itself shows that the informant and the accused, they are known to each other. And first paragraph, he said that forcibly I took her to Dudnoi instead of the UP Bank of Matia, and tried to outrage her modesty. But this alleged incident happened in the daylight on the national highway. As per the statement, is it believable that without any protest and hue and cry, I have committed that kind of crime? Basically, Lordship, FIR is lodged only on the instruction of the husband of the informant because she wanted to discontinue the friendship. And another important thing is that initially the informant approached the Matia police station. This is important, Lordship. And Matia police refused to register the FIR because they know the entire story. And finally, what happened? The accused, on instruction of her husband, approached to the SP of Gwalpara. And the SP of Gwalpara forwarded it to the local police station. Finally, the FIR came and registered. This is the story behind the filing of the FIR. And the rest of the things will reveal the CD.
And here I have received the case statement. I have 183 statement in the Here is my letter. Sufficient materials against him, as in 183 statement, CS category indicated him, how he has committed the offense. That is their method. And regarding the assaulting by family member, there one injury report. Whatever injury there or not, injury report is also here. Like,
Whatever my friend has submitted, I am not disputing. My earlier bail application also rejected on the basis of her statement. Lordship, whatever she has stated in the FIR, the same thing he has stated before the magistrate. Accordingly, her statement is recorded. But Lordship will find out whether the FIR, content of the FIR itself disclose any offense.
No, my lord, it is not the trial stage, my lord. It is the
that
prima facie material.
The prima facie material is that there is no offense.
Your bail
Because
application was earlier rejected by whom?
it is a court of the district and session judge of Gwalpara.
Have you annexed the order here?
Here, ma'am. There is page 13.
13. The only ground is that, which is in the page 14, the statement of the victim recorded by the judicial magistrate, it reveals that on the relevant day of the incident, accused Tahir Ali forcibly took the victim. It is her statement. Whatever she has stated in the FIR, she has stated before the magistrate. Lordship, in this regard, my submission is that whether any statement of the family member of the accused person was recorded or not under 161 of CRPC, because they are the eyewitness of the rape. Yes, as per the FIR. It is not my version, FIR version. FIR is telling that they assisted the accused person. She was confined and
not assisted, assaulted.
Assaulted.
Goni was allowed to go. By this order, one Usman was allowed.
Allowed, madam.
One accused person is allowed.
And here, Sir Ali bail was rejected, madam.
So as per you, discontinued relationship, no?
Exactly, Lordship, because they belong to the same FIR, and it is evident that the local police also refused to register FIR.
No. Why she lost the FIR? As per you, why she lost the FIR?
Lordship.
Why she lost the FIR as per you?
Because her husband insisted to discontinue the friendship with me, and husband suspected that it is not a simple friendship, there is something beyond the friendship. On that suspicion, he insisted.
That is their version, my lord. But CD reveals another.
The CD reveals the statement. Nothing is there, so far my knowledge is concerned. Statement, whatever the statement made in the FIR, the same statement recorded before the magistrate. But what about the statement of other witnesses? Why the IO did not record the statement of the family member of the accused person, because they were present at that night on there. And the FIR says that some people came forward while she started hue and cry. They rescued her. And who are the person to rescue her? Their version is also necessary.
Your good name is not been reflected. What is your name? Good name?
FZ Mojumdar.
F?
FZ Mojumdar.
Z. It's an application. It is submitted by Mr. Muchukka. They done it. Such also listed very effects say that the petitioner had the and subsequently only she launched it against the accused petitioner. Also, proposed he submitted that the present petitioner and the accused person had some good relationship, but as the husband of the petitioner had suspicion on the victim that she had some relationship with the accused, he insisted her about the affair. Only on the insistment made by her husband, she lost the FIR against the accused. However, the petitioner is ready and willing to extend his cooperation for the investigation of this case if he is read with the privilege of the pre-arrest. Next, Mr. Sharma, done it, he submitted. There are sufficient materials against the present petition, particularly in her statement made by the victim under section 180 and 183 PRSS. She implicated the accused persons, and as per her statement, she was raped by the accused petitioner on the night of accordingly submitted that it's not the case to extend privilege of pre-arrest to present petition and accordingly we for dismissing this. Next, but hearing this submission made by since I have also read the case diary, case diary, case diary, and also considering the statement made by the victim under section 183 and 180 PNSS. I find that the interrogation for the present petitioner may not be set for the investigation. In this, I find it witness to extend the privilege of the restrict. Okay, you can pay.
Lordship.
All right. Wait, please, Your Lordship. Lordship, before coming to the affair, just a brief, Your Lordship. One Saurabh Das, he is the owner of a fishery. One Saurabh Das is the owner of a fishery. He does business of fish. Now, this petitioner, Your Lordship, he is a co-villager of that Saurabh Das. On 4/11/2025 at about 10 a.m., Your Lordship, the son of the informant was illegally catching fish from the fishery of this Saurabh Das. Someone informed Saurabh Das over phone that he is catching fish illegally. On getting information, he went to the fishery. Now, seeing the Saurabh Das, Your Lordship, the informant's son fled away from the spot. But while fleeing away, he left the gamusa, which he was wearing by the side of the fishery. Now, that Saurabh Das picked up that gamusa and he went to the house of the informant who gave a complaint that your son was illegally catching fish from the fishery. And if next time, if I see him, I will file an FIR against him and he will be put behind the bar. At that time, Your Lordship, the petitioner who was coming out from the house, he found the Saurabh Das. Saurabh Das told that the son of the informant was illegally catching fish. I am going to give a complaint. Please accompany me. So he went to Saurabh Das. They gave a complaint to his father. After 2 days of the said incident, Your Lordship, the informant's son was found dead in a river by the side of in a river by the side of the village, and subsequently the affair came to be lost. I am neither the owner of the fishery nor I have anything to do with that victim, Your Lordship. Affair, Lordship, will get at page number 9. Is a translated copy. May I read, Your Lordship? Humble submission is that my son, namely Durgacharan Gwala, is aged about 41 years. On 4/11/2025, he was catching fish from the fishery of the accused number 1, who is the Saurabh Das, which is adjacent to my house. Seeing the same, the accused number 1 and 2, along with other persons, took him running, and my son got hidden somewhere. It was informed to me by the accused persons after coming to my house, and they also gave me the gamusa of my son. From that time onwards, not getting my son, I, along with my family members, started looking for my son. On 6/11/2025 at about 9 a.m., my son was found dead in a river adjacent to the fishery of the accused number 1. On reaching the place of incident, I noticed that my son was not having one eye and there were injuries in his body. I have doubt that the accused persons had killed my son and threw him in the river. So this is the case, Your Lordship. I am neither the owner of that fishery, nor I have any personal grudge with that. I also accompanied the owner of the fishery when he gave complaint to the informant, Your Lordship. That is what I have. I am the accused number 2 in this case. Ranjit Das.
My lord, here received the case there, my lord. But regarding the PM, my lord, cause of death is yet to be ascertained, my lord. Here PM report is not conclusive, my lord. Here kept pending for the, my lord, is FSL report, my lord. Here also FSL report also received, my lord. Here no poison is there, my lord. But final cause of death is yet to be ascertained, my lord. And I am also talked to the IO, my lord, the yesterday, my lord. He said that within 3-4 days we will receive the final opinion regarding the cause of death. And from the another aspect, my lord, regarding his involvement, my lord, here at the time of seizing, when he was caught red-handed for fishing, my lord, all of them seizing her, my lord, seizing him, my lord, to the, he then went to the jungle, my lord. And on the third 2 days, my lord, he was recovered near the pond, my lord, in a river also, near the river, my lord. And here, during the investigation, it was suspected that he was also involved, my lord, as they are seizing, my lord. In the IO note also said that during the investigation, he was found in the, my lord, place of occurrence at that time, my lord. And
Do one thing, we're not going to
my
hear the
lord,
matter. It's otherwise also AB.
my lord.
So in that case too, you have to send back the case diary or you're going to return?
Send back, my lord.
Send back.
Send back.
Send back in that case too, you need at least 1 week or 10
My
days.
lord, 1 week. Or
Where
10
from
10 days.
it has to come?
It's customer. 10 days.
Or you can retain the case diary because within 10 days, it may not reach.
My lord.
So
Then
we
we
are
retain the
going-
case diary, my lord. In the meantime, my lord, we'll call for the my lord.
that can be
Final opinion
final
regarding the cause of the.
I'll appear and cooperate, Your Lord. No, no. If there is anything else, Your Lord,
No,
I
not
don't know.
it's not.
MH, but it and be Sharma, Learned Petitioner PP appearing on behalf of the decision, no, sorry, is submitted by Mr. Sharma. A case diary received, but the opinion for that is not yet could not be collected by the IO till date. However, on telephonic information, it is submitted. It is stated by the IO that the date opinion for date will be collected within 3-4 days. In view of this, let the CDB retain till next date of listing, and the additional PP will accordingly collect the opinion for cause of opinion for debt of the cause of debt from the IO. Then when it can be listed?
My lord, then 20, my lord, 20. Today is 11.
It may not come, Your Lord.
No, no, no.
We are going to retain the case diary.
Retain case diary.
Okay, 20.
Fine.
In the interim, Lordship, he may be put. I will appear, I will give my statements, Your Lord.
No, my lord.
I am
Committed a murder of a
My lord, he is the FIR number.
obliged, Lordship.
May it please your lordship. May it please
Your petition is BA, na?
Yes.
BA, my lord. In the June portion, it come, my lord. I am also confusing, my lord.
He is in jail, my lord, since 73 days, my lord. They are in jail.
My lord, here, before starting my colleague, my lord, here, we have received the case diary without, my lord, PM report, my lord. It is required, my lord, for proper ethics.
Other textual.
No, my lord. Others, if go on merit, my lord, he is the main person.
In
Who
fact,
cut
my
his
lord,
neck, my lord.
as per my instruction, my lord, no such type of, my lord, serious incident happened there. Due to other reason, he died.
But he died.
But he died. Why? Why he died?
Died for other reason.
No, my lord, he is.
There is a simple, my lord, debate was there because the deceased married the patient number one sister, my lord. All of the family member, my lord. There was a debate only. And they, my lord, aggressive and they attack us, my lord, as per our close affair, my lord. Medical report,
My lord, here it is not required, my lord, for it is required only the medical PM report, my lord.
Today is
And
7.
the eyewitnesses are there. Several 5-6 eyewitnesses there, my lord. They have said that it was exposed in the neck, my lord,
73 days,
and died at the spot. One, he was taken to hospital. It was,
So we can do two things. Either we can dispose of the matter.
my lord, only PM report I will call. In the morning also I talked to IO, my lord. He said that, my lord, he is on leave, my lord. That's why he placed some time, my lord, for collection of the PM report.
But now he is saying that he is in custody for 73 days.
73 days.
My lord. But otherwise, if in the merit, my lord, then sufficient matter, sir. All the eyewitnesses are there.
So they have come. Our close affair also happened.
Not necessary.
Because they have come in my house, my lord.
No.
They entered forcefully in my house and they attack us. We are the victim actually, man. And somehow, for other reason, he may die, but they have.
But there is no right
held
to
this up.
take the law in hand.
No. As per my instruction, no such type incident happened.
But
They
died, my
came.
lord. One person died.
Right for other reason.
PM reported.
So we are going to return back the case right from where it has to come.
My lord, Gwalpara, my lord.
Only for PM report we call for, my lord. Diary may be detained here. Because already 73 days, my lord. Ultimately,
If it can
They
be
are behind the
written,
bar.
can it be written, but 20 very recent date we can
My lord,
here,
my
not,
lord, my lord, it is not.
here with full of date. This or here.
26 or 27.
My lord, the institute is almost going to
No,
be over,
no,
my lord.
my lord.
If, my lord, possible, then, my lord, on 17, my lord.
No, it is
Not
not.
at all possible.
6, 17
at all.
days he is behind the bar. Police
It
is
is 90
time.
days offense.
We are not
It
in
is
a
90
position
days
to fix
offense,
your
my
date.
lord.
They,
Eyewitnesses are there, ma'am.
then only for collecting the medical report, how much time will need? Already more than
No,
2
we
months
don't
ago.
have date. We cannot fix your date on 17. That's what I'm saying. Let's take this date, Monday. Okay, well, somehow we're fixing it on 20. We said 2020. Just you call for the report.
Ma'am.
Retaining the case diary.
Ma'am.
Mr. and P. Sharma, subject by Mr. Sharma. That's case diary. Case diary is received. However, the PM report is not available in case diary, and accordingly, he submitted. Then he will take instruction and will call for the PM report. In that view, let the CDB retain the next date of listing. List the matter accordingly on 20/02, asking the learned additional PP to obtain instructions of the PM report.
Ambulance, madam.
My lord, CD was called for the anticipatory. There is no interim, my lord. And there are 4 persons here, my lord. Petitioner number 1 is the father of petitioner number 2 and 3.
Petitioner number 1
is the father of petitioner number 2 and 3. And petitioner number 4 is the cousin of petitioner number 2 and 3.
Okay.
So FIR, my lord, she will find page 9, my lord. My lord, the allegation that my lord give us hat. Or other sections are my lord available except 1172. That means earlier 326 IPC. My lord, CD will reveal, my lord. CD call for everything, my lord. Probably injury report also there. So my submission before your lordship, already, my lord, after filing this, my lord, petition, bail petition, 35 notice were issued against me, my lord. Although before that, I have already filed my lord this petition. Probably that is in the record, my lord. But that is already over. So I am not on interim. That's why I am not appearing, my lord. So as per so far my information, my lord, received from my junior, my lord. So all the 4 are not involved, my lord. All the 4 persons. Something happened, my lord, in between, my lord, some of them. That is correct, my lord. But so far is, my lord, all the 4 persons, my lord, they are, although there is a allegation against them, my lord, in the affair, my lord. Accused number 1, 2, 3, and 4, my lord. Matter নাই না
Yes.
Yes, my lord. Case diary received, my lord. In this case, my lord, I have received 3 injury reports, my lord. One is grievous injury, my lord. A cut injury, my lord. A head, my lord. Peritoneal region of head, my lord. And my lord, other 2 injuries, my lord. Simple injury, my lord. In this case, I have, my lord, along with other materials, I would like to first point out, my lord. In this case, FIR was registered on 26/1/26. My lord,
FIR
incident
was registered on
26/1/26 at 6:20 p.m. And my lord, incident occurred on 25/1/26, my lord, 11 p.m. My lord. My lord, from the materials available on in the case diary, my lord, what happened on the day of the incident? All these accused persons, my lord, all are, my lord, it seems from the case diary that all are criminal minded, my lord. Along with the sharp weapons, my lord, type of weapon, my lord, what they were carrying at that point of time, that is also their photograph also available in the city. On that day, my lord, all these accused person initially went to the, my lord, hotel of the victim, my lord, one Maya hotel. Initially they attacked one of the employee of that hotel, my lord, one Porimol Tati. My lord, he was also injured. His injury report is also available. His statement is also available. And thereafter vandalized, my lord, all the hotel premises, rooms, my lord, everything by all these accused persons. Thereafter, my lord, not finding the, my lord, victim, that is, my lord, Rinku Sodhari, they went to the residence of the, my lord, victim. Thereafter, my lord, in the residence, after pulling the victim, my lord, outside, in presence of all other witnesses, my lord, they brutally assaulted, my lord, with sharp weapon. What type of weapons they were carrying, my lord? Dao, my lord, and sharp weapons. That photograph is also available, my lord. And thereafter, my lord, all these accused persons in a group brutally assaulted the, my lord, victim, all these victim, my lord, victimized persons. Thereafter, my lord, injured, my lord. And my lord, initially, my lord, there are initially after attacking Porimol Tati, all these accused persons again attack all these, my lord, other accused persons. And regarding that, my lord, later on, my lord, considering the, my lord, nature of the injury, IO has also added section 109 of the BNS, my lord. Attempt to murder, my lord. And from the, my lord, statement of the witnesses, my lord, and your lordship, if your lordship wants, your lordship may kindly present all these accused persons in a group, my lord, brutally assaulted. And they are, my lord, from the materials available and from the photographs of all those weapons, my lord, it cannot be said that there is enmity also. There is enmity, previous enmity between the my lord, accused person. There is also their note regarding that aspect. In fact, my lord, while police went to search the present accused person in the residence of the accused, then their statement of the, my lord, wife of the accused is also available. Because after committing that, at that point of time, they went to the residence of these victimized persons, my lord, regarding some, my lord, dispute, and thereafter, my lord, immediately thereafter, while police search, their mobile, my lord, is found switch off. So these are the, my lord, materials against the accused person. So considering the nature of the nature and type of weapons they, at the time of, my lord, committing the offense, they were carrying with him, my lord. They are in fact when they are to actually kill the accused persons, but because of the intervention, because of the hue and cry intervention of the, my lord, public of the, my lord, neighboring area, my lord, ultimately they fled away from the spot. But my lord, grievously injured one victimized person and other 2 accused persons were also, my lord, seriously injured, although their injury is simple, but my lord, laceration and, my lord, injury, my lord, is there, my lord, in vital portions, my lord. So considering all these aspects, my prayer before your lordship, considering the nature, my lord, of weapon they were carrying with them and the type and the way they, how they have committed the offense, at least, my lord, this is not a fit case for anticipatory bail.
Yes.
So, my lord, no, wait, no, me complain, no?
My lord, in this matter, my lord, I appeared on the first occasion, that is on 2nd February 2026, my lord. Certain observation recorded by this honorable court. I'd like to draw your lordship attention the last order.
Last order?
Yes, my lord. On the notice issue, CD call, and my lord, my submission also recorded, my lord. What is my submission recorded is also very relevant. Your lordship will find from 3rd paragraph I will read it. The petitioner counsel submits that a notice has been received under the Statutory BNS It is also submitted that the wife of the petitioner number 2 gave birth to a child to now. Judge Learned Counsel for the informant submits 2 photographs purportedly of the victim's brother indicating severe bleeding injuries on the head, and it is submitted that he is admitted in Rahman Hospital, Gauhati, Kolkata. Now my submission in this paper. On very that occasion, Milord, I requested repeatedly I requested the counsel for the petitioner to submit one copy of the bail application, but till that the application of bail application has not been served to us. And Milord, the recent information I received from my client, Milord, is in still in the undergoing treatment in the Rahman Hospital, Milord, and condition of my client victims, Milord, it is a critical and serious in nature, Milord. And Milord, what those photographs were perused by this honorable court, therefore this honorable court has not granted in fit to grant the interim protection, Milord. Those photographs I like to produce before this court, Milord. And most importantly, Milord, so 1172 and 11 is the voluntary causing grievous hurt and voluntary causing heart on grievous hurt by dangerous weapon. So my public prosecutor has already placed before this court, Milord. And moreover, Milord, and recently 109 also, that is attempt to murder also recorded in this edit, Milord. Lordship, no, I don't know what is the points they have stated in their bail application. Same has not been furnished to us. Despite a repeated request, my junior has asked to furnish one copy, but same has not been furnished to us. But I don't know what is written in the application, Milord. Those photographs, Milord, at the Rahman Hospital, I was admitted with some materials I have been, so I have to place before this court. Moreover, Milord, one decisions of the Honorable Apex Court, Milord, what is the role of the victim while granting in the bail application? But what is the role of the court, and what is the victim protections necessary in this matter, Milord? This honorable court has decided this matter on Jagdish Singh versus others. I love to place this. And these are the photographs. So after doing all these heinous offense, they approach before the court protection, Milord. This present petition approach before this court, Milord, don't deserve any lenient view from this court, Milord. Already material placed by the learned public prosecutor before this court, Milord. Even the accused wife made some statement that they went in the house of the victim. Yes, Milord, they went in my house and attacked my brother, Milord, including me, myself, Milord. Informant, I also received injuries, Milord. So far as my brother is shown that he received previous injuries. So my family object in this matter. So Lordship, considering all the materials, evidence as whatever the place before this court right now, Milord, as well as case report, Milord. So, Milord, the petitioners, the bail application before bail, they may be rejected. That's it, Mr. They don't deserve any protection.
My lord, regarding non-submission of my lord, the non-furnishing of bail application, that is, I am not know, my lord. I am being engaged yesterday only. That is, my lord, probably long when earlier I was not moving. I do not know regarding that, my lord. I'm sorry that if it is not done, it is a really not good things done, my lord. It should have, instead of my lord making submission before this honorable, if he asks me like any question, my lord, definitely I'll ask my junior to, my lord. That is no, in such a situation it will be amazing for me, my lord, because he says that I have not been normally in this type of petition. If it is, my lord, his aim and objective is, my lord, that not anything to inform before you are done. Did he inform? I don't know, my lord, whether he is asking for a copy or not. I'm not on that, my lord. But my lord, if it is happened, my lord, I'm taking responsibility. It's a bad thing he has done, my lord. I'm sorry. Anyway, my lord, your lordship kindly see, since, my lord, how many injuries are there? If there is a grievous injury, only one grievous injury, how does all the force are involved, my lord? My submission before your option. Now, another things, my lord, there earlier regarding, my lord, 107, my lord, probably that attempt to murder 109. That is, my lord, subsequently added. Probably I am not aware of this, but why I'm submitting, because 135 notice has been served on me. That meaning thereby all the offences are under, my lord, 7 years, my lord. So 107, I think attempt to murder is not probably life. So that's why that is not in my knowledge. Your lordship kindly.
Heart was also initially registered, I think.
Yes, initially, my lord, 117 and 118.
118 was already there.
There, my.
Then why 35 was there?
Yes, well,
Why 35 was there?
My lord, because initially, my lord, 109 was not added and 35(3) notice at that point of time was issued.
No, 1188 is also 7 years after, or it can be extended.
Yes, 1 is 7 years.
Yes, my lord, earlier
Only after
section.
Earlier 7, correct.
Earlier 376 was
The
326
1
was
year
not 7
7
years.
probably there are two parts.
Two parts are
Two
there.
parts. Even on 117, if you come to the second part, my lord, then my lord, it will be up to life. So, but probably 1172 and 1182, 1183 is my lord probably life.
118.
So can you tell us under which section it was registered?
1182.
1182.
2 is registered here. Probably 3, my lord, that is not, that part is. No. 10.
Extend to 10 years. Then extend to 3 years. 1181 and 2.
Hmm? One of them. Some notice condition. 1172 and 1182.
Yes, earlier 11, my lord, at present 1172, 1173, my lord, in all those offences, my lord, shall not be less. So
1173 is life.
Life.
my lord,
Who is my lord? No.
yes, 1173 is my lord life. So earlier also that section was there, my lord, before adding 109.
No, 1 and 2 is there, not 3 is there. 3 is life.
No, 3 was also there. 1173 was registration.
Registration 1 and 2.
No, 1173.
No, at the time of registration,
No,
1173.
3 was there. 1173 there.
No. Certificate, okay? Two. Anyway, I am not on that mind. Already subsequent. Certificate.
But 1182 was also there.
Yes,
Initially registered 112. 1182. 1182 was there.
Yes, 1182 was there. And my lord,
No, 1 is 118. 1 is my lord life. 18(2) is not my lord life. But is which may extend to 10 years. But it is not anyway, my lord. Probably they are by mistake. They have my lord 35 notices been issued because 118, 1 and 2 both are minimum 10, maximum life.
Life, yes.
So anyway, my lord, your lordship kindly see, my lord, how many injuries are there. All the 4, my lord. If there is any evidence, all evidence against all the 4, my lord, then I have no case, my lord. But suppose, my lord, with a Dow, my lord, with a sub weapon, all the 4, my lord, giving a attack, then there will be, my lord, more than 1, my lord, give you a shot, my lord. But they say that other injuries are, my lord, simple. So whether is the involvement of all the, my lord, 4? That has to be looked into, my lord.
Just tell us, the case was also registered under which section? Subsequently, 109 is added, I can understand.
109 added.
My lord.
Added, but initially?
Initially 109 was not there.
Not
because
there.
At that point of time, injury report, my lord, everything was not available. After obtaining that injury report and my lord, everything, my lord, at that point of time, initially, my lord, preliminary at the time of investigation, that was not added. Later on, my lord, finding all these materials, but 109 was there.
So for
And at that point of time, other section 1182 and those sections were already there.
No, for 109, my lord, earlier 107, 307, that, my lord, injury report is always not required. But when there is an injury, we have to go by
point of time under the impression that all offences were of 7 years, so IO has issued section 35(3) notice to the accused person. Although, my lord, not at all required. And my lord, regarding other, my lord, statement, your lordship may kindly statement of the witnesses, specific allegation against the accused person is also there, and the accused person in a group, my lord, how they, along with those weapons, my lord, entered into initially to the my lord, premises of the hotel, thereafter vandalized the, my lord, my lord, hotel premises. Thereafter, immediately in a group went to the residence of the present petitioner. So, from all these aspects, my lord.
No, some
I am
incidents.
asking that whether any sections, because of the thing that it was also registered under 189, 189, that is unlawful assembly.
Unlawful
isn't
assembly.
it?
Unlawful assembly.
That's what I am just asking. Because if it is there unlawful assembly or 3-5 was there, then
No, unlawful assembly, my lord, that will not come because it is not, because unlawful assembly, the 4% has to be required. Then only they are not name only 4%. 5% is required for unlawful assembly.
Anyway. Okay, then.
At the time of inserting of the, my lord, sections, otherwise from the materials available on record, my lord, they will not.
Actually, my lord, incident, my lord, why this
So
incident
you are
is happened?
insisting that only one injury is there?
My lord.
So it may be.
So, my lord,
caused
what
by
are
only
the,
either of the
my lord, what are the evidence against all the 4 accused, my lord?
No, they are saying evidence against
My
all
lord,
four?
my,
Yes, Mr. Bodhak.
Yes, my lord. Your lordship may kindly peruse the statement of the eyewitnesses, specifically, my lord. Although Bapan Dev is the main person who has inflicted with the dao over the head of the, my lord, accused person, regarding other accused persons also, there are statement of the witnesses. They, along with all others, my lord, assaulted the victimized person, and they were
correct,
also,
my lord, that injury.
they were also, my lord, at that point of time carrying, my lord, weapons along with him, my lord, and photographs of the, my lord, weapons dao, my lord. That photograph is also available, and my learned friend now, whether the type of injury, my lord, that photograph, that is also available in the CD also. And my lord, the statement at that point of time in the residence of the present petitioner, brother, his mother, my lord, statement, everyone's statement, all are eyewitnesses, their statement is also available. One Porimal Tati, who was injured witness, his statement is also available. In fact, informant was also injured witness.
Actually, my lord, real fact is not that, my lord. We are a owner of
regarding, my lord,
I am a owner of a wine shop, my lord, and my lord, and that is the next day is 26 January, and they are running. They are owner of a hotel. They by force, my lord, taking liquors from my restaurant, my lord, and that is the starting point of the incident, my lord. And that's why one or two employee of the my lord, one father and my lord son, they cannot, my lord. That is impossible, my lord, to go and attack the all, my lord. So that's why I'm submitting, my lord, all, because that point of time actually we should not have, we should have, my lord, inform the incident to the police, my lord. Because I'm owner of this wine shop. They by force they have taken away, because that was a dry day. They forced us to open the shop and take into their hotel, my lord. So that was the ideal fact, my lord. But anyway, my lord, your lordship kindly go by the injury and see the, my lord, is there a specific allegation that, my lord, he has taken part? Because there is only one grievous injury. Since it is one grievous injury, then how this, my lord, if it is a simple, my lord, they are, my lord, not entitled for any, they are not been given any, my lord, they may be entitled to get bail, my lord. So that is my submission.
Your lordship also will have to look one other aspect, my lord, regarding their criminal intention. Your lordship may see, initially they went to the, my lord, hotel of the, my lord, informant, along with those sharp weapons. If their intention is good, there is no intention to, my lord, attack these, my lord, victimized persons. Immediately they would have stopped there, my lord. Thereafter, my lord, along with those sharp weapons, my lord, from hotel they went to the residence of the, my lord, accused persons, along with those, my lord, sharp weapons, with, my lord, in a group, my lord. So their, my lord, criminal mind is, my lord, reflected from their mens rea is, my lord, to, my lord, intention is very clear.
Heard Mr. T.J. Mohan, the learned senior, assisted by Mr. F. The learned counsel of the point. It is submitted by Mr. Mohan that that there was a quarrel of the took place between the two groups. There is such they have not inflicted any such injury on the victim. However, as per the information, one the victim sustained some simple injury for the alleged incident. If it is submitted that on the day of incident, that is on this is 26 January, it was a dry day, and the accused and the informant side and forcibly make them open the wine shop and from there they took fine to their hotel PROCEED. Due that for that reason only there was a quarrel between the two groups, and apart from that there is no such incident took place as allegedly applied. Further, he submitted even if it is the grievous injury is sustained by a person, it seems that only one injury was sustained by the victim, and that cannot be caused or be inflicted by all the accused persons as named in the FIR. The petitioner number 1 is the father of petitioner number 2 and 3, and 4 is their cousin. Thus, they all belong to the same family, and it is not also believable that both sons and father will go together with a criminal with an intention to assault the informant side. He further submitted that all the accused petitioners may not be involved with the alleged offense. However, there may be accordingly it is submitted by him that even if one injury, a previous injury was caused by one of the victim, that cannot be inflicted by all the accused persons, and thus the section 117 with 1182 cannot be attracted against all the accused petitioners. In view of this, the petitioners are also entitled for the privilege of pre-arrest bail. However, they are ready and willing to extend their cooperation in the further investigation of this case if they are allowed to go on. Next, Mr. Mohanto also raised the issue that prior to the filing of the present petition, the petitioner number 1 received the notices under section 35(3) BNSS, from which also it can be considered that initially the case was registered wherein the offense was wherein the penalty was only for 7 days. Considering the penalty was only for 7 days. The petitioners being the local person, there is no chance of absconding. Rather, they will extend their cooperation in further investigations. Next part. Mr. Porter, the learned petitioner PP submitted in this that all the accused petitions went together with a criminal mind to kill the victim, mainly Rinku Chaudhary, and they all went there to the house of the Rinku Chaudhary with the sharp weapon. Further, he submitted that initially they visited to the shop of the hotel of one Porimal, and trying to and searching for Rinku Chaudhary, and in that process they also vandalized the hotel and also assaulted the said shopkeeper, that is Porimal. Thereafter, when they did not find the victim of the Rinku Chaudhary, they went to the house with a criminal intention and with a criminal mind, and assaulted all the victims, causing previous injury to one person and and simple injuries to the others. Mr. Waterpool further submitted that considering the nature of the injury as well as the conduct of the accused petition, the 109 is also subsequently added during investigation. Mr. Waterpool accordingly raised women objection and submitted that it is not at all a case for granting pre-arrest bail to the present petitions. Next, Mr. Dekka, the learned counsel appearing for the victim informant submitted in this that the that one of the victim who sustained previous injury is still under treatment, and presently, as per his information, he is admitted in Rahman Hospital, Gauhati, for further better treatment. Mr. Dekha further submitted that the intention of the petitioners was to kill the victim, but due to interruption of the other family members and the local persons, they could not kill the victim, but assaulted brutally with sharp object, causing previous injury of this person. Accordingly, Mr. Deck also raised objection and submitted that it is not the case to the privilege of pre-arrest bail to the present petitions. Next point, during this submission made by Anil Council for first case died and the other annexes petition. As per submission made by the learned council petitioner seen that the 35(3) notice was issued to the present petitioner, but it is seen that case was already registered under section 17182 BNSS, and it may be a wrong impression while issuing the notice under section 35(3) BNS. It is further seen that during the investigation, 109 BNS is also added. It will be added to the present case. It is it may be a case that the person may sustain, the victim may sustain one grievous injury on his head, but from the entire facts and circumstances of this case, it is seen that all the accused petitioners went together with a criminal intention, and in the night of offense, they entered into the premises of the informant, brutally assaulted the victim, especially the victim who sustained the previous injury. More so from the materials available in the case study, it is also seen that their intention was to cause grievous hurt of the kill the victim, and with that intention on, they also visited to shop of one Porimontas, and as he could not be as the victim Rinku Chaudhary could not be dressed out in could not be was not present in the in their hotel. They immediately came to the house of the informant victim and assaulted all the victims, brutally causing grievous injury. Thus, it cannot be it seen there may be one previous injury on the head of the victim, but that reason only cannot be considered that the other accused persons are not involved in the arrest. Considering the entire facts and circumstances of this case, nature of injury sustained by the victim, and also considering the criminal conduct of all the accused petitions, I do not find it a fit case to extend the privilege of the arrest bail